Thank you. Sorry.
That's okay. I'm gonna run back across the street. You on Zoom?
It will be just a little bit, so you're okay.
Ready, Tammy?
Yes, sir, you're ready. I'm just waiting for his exhibits to come in.
All right, we're on the record by Zoom and cause number 19-2780-C, John Michael Dodson, plaintiff, versus Garrett G-E-N-A-D-E and Artesian Millworks and Builders LLC, defendants. I believe plaintiff's counsel is present, is that correct?
Yes, Your Honor.
It appears, just looking at the file, that I actually had a plaintiff's motion for default judgment.
Yes, Your Honor. I believe we're here on a hearing on the damages.
That's the way it looked. All right, so counsel, let's see, is there anyone here? Is Garrett Grenade, G-E-N-A, just for the record, is Garrett Grenade, G-N-A-D-E, on Zoom present? No.
And Your Honor, just to be clear, this motion is against Artisan Millworks and Builders and not against Garrett Gannett individually.
No, I was looking at that because, I'd signed an order on the plaintiff's motion for default judgment, granting the plaintiff's motion for default judgment against defendant Artesian Millworks and Builders LLC. That was file marked back July the 20th, 2019. Because the damages are unliquidated, the court will hear evidence of damages on August the 12th at 9:30 via Zoom. So that's obviously what we're doing today. So go ahead, counsel.
All right. Can we go ahead and swear in witnesses?
Sure. Who all you got?
Just myself and Michael Gately.
All right. Raise your right hands. Do you solemnly swear the testimony you'll give before the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Okay, counsel, go ahead.
Plaintiff calls Michael Gately. And Mr. Gately, just so you know, you're on mute right now.
It's Michael Gately, G-A-T-E-L-Y, by Zoom. Okay.
Okay, sorry about the mute.
Okay, we got you. We got you, Mr. Gately. Go ahead, counsel.
Please state your name for the record.
Michael Thomas Gately.
And what is your relationship to John Michael Dodson, the plaintiff in this case?
He's a longtime friend. I've known him for about 33 years.
Okay.
Met through my wife.
Okay. And the transaction that makes the basis of this lawsuit, what's your connection to that?
Well, my wife and I retired out here at a hideaway in Smith County. And we've been friends with Michael for a long time, both living in the DFW area. And when we told him that we were going to retire out to Hideaway, he thought that he might like to retire out here also. He purchased the lot to build a home that he
let me jump in. Is it fair just to say that Mr. Dodson was purchasing his home, but you were the guy kind of helping him manage everything?
On site, yes, sir.
So if we were gonna find the person best able to and most qualified to give insight into the transaction between Mr. Dodson and defendant Artisan Millworks, you would be that person.
I believe so, yes, sir.
And everything you're saying is going to be based on your firsthand knowledge of this transaction.
Yes.
It's fair to say you were the point man between the two.
Exactly.
Okay. So can you describe the transaction between Mr. Dodson and Artisan Millworks?
Sure. Michael was looking for a home builder, and on a recommendation of someone we trusted, he picked Artisan. I was actually there in July of 2018, standing in front of Michael Dodson's lot when Garrett reviewed Michael Dodson's plans for a small home and agreed that he could build a house for $130,000 on that lot.
Okay, and so when we say Garrett, we're referring to Garrett
I'm sorry,
Garrett owner of Artisan Millworks.
Exactly, yes, sir.
And just one thing, I know it's a little difficult with Zoom, just to make sure we're not talking over each other. So sometimes it's just do your best, and sometimes it's a little hard. Okay, so you approached him to build a home for Mr. Dodson.
Yes.
Can you tell me what happened next?
So the price was set at $130,000 because that's the equity that Michael had in his home in DFW. Mm-hmm. And things were going to get started real fast, but then there was this delay when Garrett went out to Colorado to do a job. So everything was kind of on hold for a while, poor communication. But the next I heard, the job had started, and Michael was very excited. Michael Dodson was very excited to tell me that he'd just written a check for $19,000 for Pella windows. And that was my first alarm, because 15% of the price of a home just for windows didn't seem right.
Mm-hmm. So it was at that point that you decided to kind of get involved and try to kind of get some more structure to this transaction?
Exactly. I'd had an experience in program management. So the first thing I did is ask to look at the contract. Michael admitted that Garrett had never sent him one. We requested one. He sent a one-page document. As I said, that's not right. We asked him for a full document that talked about warranties and responsibilities and things. He kept claiming he had one, but never came up with it. So in early March, I purchased software that answered questions. You come up with a builder's contract, and worked with Garrett to come up with a list of the remaining tasks and an estimate for each one. I added $10,000, and we came up with the number $160,000 to get the job done.
Okay, I'm going to show you a document here. May I share screen?
I'm sorry?
May I share screen to introduce an exhibit?
Sure.
It's I need host permission.
She just had to step out for a moment.
The host stepped out of the courtroom.
You're right. We'll work around it to keep this moving, and then
she'll be right back, but if you want to work around it, that's fine. She had to go get some.
All right. Well, make an offer that I will introduce an exhibit showing the contract. Can you describe what you just said that the total contract price was $160,000? Is that correct?
Yeah. So that was going to be up from the $130,000 he originally said he could build the home for. And good or bad, it listed a set of tasks, something called dry-in, septic, plumbing, electrical, HVAC, et cetera, and included a $10,000 buffer. So I felt good that we had a contract in place, and we set up weekly meetings. I had a spreadsheet going. Hopefully we're going to be back on track. It just didn't turn out that way, though.
Okay. And we'll also introduce a spreadsheet when we get a chance that shows your total expenses. Do you recall off your top of your head what the total expenses were?
In the end, to build this house, it cost $270,000.
Mm-hmm. And I believe, though, with the things that we were looking through in the contract, correct me if I'm wrong, that we ended up spending, I can pull up the amounts here that were numbers that we were looking at for the things that he was going to deliver for $160,000. We ended up spending $193,356.26.
Exactly.
Correct?
About $33,000 over.
So $33,009.97 over, correct?
Yes, sir.
And there were some change orders that you agreed to, and the contract did allow for change orders that we would pay extra for, but we did pay that extra amount. And this exhibit will show that's been reflected in the $33,009.97 figure, correct?
Yes.
Okay. So as this progressed, and you informed him that we were going over budget, that the contract set a maximum price, what did he tell you?
It was very painful. We had these weekly meetings, and he was always full of excuses, and I'll get back to you on that. And it was just horrible to see. Just not a good businessman, not a good record keeper. You know, he'd show up sometimes with a piece of loose leaf paper with some notes and say, you owe me this much money. But based on the contract, we continue to pay our invoices, including the 10% contractor fee, and just saw things spiraling out of control. There was one point in I think it was about April 15th, when he admitted that we're going to need about $70,000 more. And it's like, wait a minute.
You never agreed to pay the extra amount. In fact, you repeatedly told him you're over budget. You know, this is not working.
Exactly. But now we're in a bind because we had invested already all of the funds that Michael Dodson had available. He's on a fixed income, Social Security. and this was the amount of equity in his home, and we couldn't back out. We had a half-built house. So this is actually about the time that we reached out to Mr. Jesse Mellister and said, what do we do? And Jesse suggested we continue to build the house and try to recoup the funds later.
And somebody else was brought in to manage the completion, and it later turned out that he claims that was someone who worked for him. But in any event, you continue to make the payments to Artisan Millworks.
Exactly.
Correct?
Yeah. Yes. Garrett Ganade and Artisan brought in a fellow named Dennis O'Hara, an Artisan employee, who was a much better business person, a much better builder, and helped us get to the completion, but at over twice the price.
Okay. All right. And so when I get the opportunity, I'll introduce a demand letter was sent informing, after the completion of the job was sent to Artisan, informing Mr. Ganade that you had gone over budget. The contract specified $160,000 and demanding that he pay the overcharges. Did he respond to that favorably?
No.
Has he reached out to communicate to you in any way that informed that he's going to pay back what was overcharged?
One time he called me to kind of challenge the whole notion, hung up early, never promised anything.
Okay. And Your Honor, yesterday I uploaded a proposed order. I'll also introduce that as a summary of our request for relief. In this proposed order, we are asking for breach of contract damages of $33,009.97, pre-judgment interest at 6%. That dates back to the final payment you made was October 7th of 2019, correct?
Yes.
Which gives us pre-judgment interest of $1,627.89. I will testify in a second on attorney's fees and court costs and post-judgment, but I have nothing further for you.
Thank you.
There's another individual up on the screen, but it says Laura Gately. That doesn't look like Laura Gately to me. Who is that?
Your Honor, that's the plaintiff, John Michael Dodson.
Okay, that clears that up. Thank you.
He's using my wife's computer sitting next to me.
Okay, thank you.
Thanks
All right, now
for
the council, you sent a proposed judgment, is that correct? I think
Yes, Your Honor.
you just said you did. I'm trying to be sure that I've got it.
It was received yesterday.
You
Again,
received it yesterday?
Yes, Your Honor.
Let's see here. Let me double check here and see if we've got it. Okay, well, I've got here under the file, which I hadn't picked up. Under the file, there is a final order. I would imagine that's what you're referring to. It's 192780-C, John Michael Dodson versus Garrett Janae, GNADE, and Artesian Mill Works and Builders, LLC defendants. That final order, the court renders judgment for plaintiff one. Accordingly, the court orders that plaintiff recover the following from defendant joint and separately: actual damages in the amount of $33,009.97, exemplary damages in the amount of $0, pre-judgment interest on the actual damages awarded at the rate of 6% from October 7th, 2019 until the date of this judgment in the amount of $1,627.89, reasonable and necessary attorney's fees in the amount of $4,814.50 for the prosecution of this case through judgment. Court costs $674.31, post-judgment interest on all of the above at the rate of 5% compounded annually from the date of this judgment is entered, which will be today, until all amounts are paid in full. 2, the court further orders that if defendant unsuccessfully appeals this judgment to an intermediate court of appeals, plaintiff will additionally recover from defendant the amount of $10,000 representing the anticipated reasonable and necessary fees and expenses that would be incurred by plaintiff in defending the appeal. 4, the court further orders that if defendant unsuccessfully appeals this judgment to the Supreme Court of Texas, plaintiff will additionally recover from defendant the amount of $25,000 representing the anticipated reasonable and necessary fees and expenses that would be incurred by plaintiff in defending appeal. The judgment finally disposes of all claims and all parties, and court would find is not appealable. But counsel, if you want to have the right to appeal, it's fine with me. That's the judgment I'm going to sign. Let me be sure that I'd gotten some other documents here, just to be sure that, I know that at the top, the first one says construction contract owner. Is that
Those are the exhibits.
is that an exhibit?
Yes, John, they should be labeled on the bottom of each page with exhibit 1 through 5.
All right.
And just to run you through them, 1's the contract, 2 is a spreadsheet of all expenses paid, 3 is the Chapter 38 demand letter, 4 is the delivery confirmation, and then 5 is just the judgment that you read.
All right, court is, of course, obviously without objection, this being a default, the court is admitting into evidence, making it part of the file, plaintiff's exhibits 1 through 5, just identified by plaintiff's counsel.
And Your Honor, do you want just brief testimony on fees, or is the proposed judgment sufficient?
Well, I suppose just for the record, as we say, I mean, the proposed judgment certainly looks sufficient, but why don't you just go ahead and put it on the record in case it's raised later somehow?
Yes, Your Honor. I called myself Jesse Mellister. My name is Jesse Mellister. I'm an attorney licensed to practice law in the states of Colorado and Texas. I've been licensed to practice for 12 years. I am familiar with the reasonable and necessary cost to prosecute a case such as this. Presently, with an estimate of an hour and a half for this hearing and preparation, my total time on this case comes to 17 hours and 50 minutes for a total fee of $4,814.50. That is based off of an hourly fee of $300, which is reasonable and necessary in this area. There have been court costs of $674.31, which include filing fees and the cost of service of process. Artisan Millworks has a registered agent in Texas, but nobody is at that address. So there was some additional fees and skip traces that were needed to be performed to try to track them down and out in Colorado. So that leads to just slightly higher court cost than typical for a case like this. But I have no further questions of myself.
All right, the court takes judicial notice of the entire contents of the file, which I believe I mentioned earlier does include, of course, the plaintiff's motion for default judgment, and then also the court's order on the plaintiff's motion for default judgment, just for the record, that signed on July the 20th, 2020. The court signed an order granting the plaintiff's motion for default judgment against the defendant, Artesian Millworks and Builders, LLC, because the damages are unliquidated. The court will hear evidence of damages on August 11, 2020, 9:30, which we're doing today. That order granting the plaintiff's motion for default judgment was signed on July the 20th, 2020. The court's going to sign the final order, which I believe I just read through, which is before the court, which will be, of course, signed and entered this date by the trial court. Is there anything else, counsel?
No, Your Honor.
Mr. Lester, is there anything else?
No, Your Honor.
All right, the final order signed, entered, and will be file marked electronically today. If there's nothing further, then let me ask one question. Down here at the fellow up here at the bottom of the screen says Laura Gately.
Yes.
Just for the record, who's that?
That's
John Michael Dodson.
the plaintiff,
Okay.
John Michael Dodson.
That's what I wanted to clear up, just for the record. I thought that would be the plaintiff, John Michael Dodson, but for some reason it was showing Laura Gately, so I want to clear that up for the record. If there's nothing further, counsel, the court signed the orders. They'll be forwarded to the clerk's office here in a few minutes. They'll be electronically file marked. Then my court coordinator will be sure you get copies of all of them. Is there anything else?
No, Your Honor. Maybe be excused.
Yes, sir, you may be. Thank you very much.
Thank you, Your Honor.
I've been
Thank you, Your Honor.
practicing in front of you, so I just want to say that thank you very much.
Yes, sir. Thank y'all too. Have a good day.
Thank you.
Thank you.
this Christopher Rawlings?
Hey, he's in jail.
I know, is that who's up there?
Yes.
Okay.
All right, let me close the door.
How y'all doing today?
We're doing all right. How you doing?
Good.
Tap the check.
How you doing today, Mr. Robinson?
Doing pretty good, Christopher.
I can't hear. I can't hear. I can't hear the other man.
We haven't started yet, Christopher. You're here when you get started.
Okay.
All right, we're on the record now in calls number 241-0587-20, State of Texas versus Christopher Rawlings. On an indictment charging possession of a controlled substance, state jail felony. This is all by Zoom. The defendant, Christopher Rawlings, is present by Zoom with his attorney, Mr. Clifton Robertson, present by Zoom. State's attorney, Mr. Heath Chamness, is present by Zoom. Indictment in the case charges the offense, as I've said, of state jail felony, possessing a controlled substance, namely methamphetamine, in an amount of less than 1 gram. Just raise your right hand, Mr. Rawlings, so I can get you sworn in on this plea. Do you solemnly swear the testimony you'll give before the court today will be the truth, the whole truth, and nothing but the truth, and all the documents which indicate you have sworn to them were sworn to you by them, by the documents, freely, intelligently, knowingly, and voluntarily?
Can you hear Christopher?
Yes, sir.
You're
Okay,
the
now,
judge?
do you solemnly swear your testimony will be the truth, the whole truth, nothing but the truth? And if the document shows you signed and then swore to it, you're swearing to it freely, intelligently, knowingly, and voluntarily? That's the oath.
Yes, sir.
Okay, you can go ahead and put your hand down there. We're gonna go through your documents. You have a plea agreement with Mr. Chamness, where if you do enter a plea of guilty to the state jail felony possession of a controlled substance, Mr. Chamness is going to recommend your sentence to the court at 5 years deferred adjudicated probation. Is that the plea agreement, Mr. Robertson?
That's
Yes.
correct, Your Honor.
Is that your plea agreement, Mr. Rollins?
Yes, sir.
You're going to see, you look at the screen now, you'll see the agreed punishment recommendations. That is 5 deferred. There's a signature K. Rollins on the line above where it says defendant. Is that your signature?
Yes, sir.
All right, that signatures on all these plea documents. I'm just going to go through and identify them for the record. There's an acknowledgement of admonishment signed by you and your attorney. There's a waiver of trial by jury signed by you and Mr. Robertson, where you tell me you understand you have a right to a jury trial, but you knowingly waive, meaning give up your right to a jury trial. Just request the court to hear your case on your plea of guilty today without a jury. Is that correct?
Yes, sir.
Then you're signing and swearing to a waiver of confrontation with witnesses. You're signing and swearing to a stipulation of evidence. States Exhibit Number 2, the stipulation of evidence states 2, signed and sworn to by you. That is a written judicial confession by you under oath to all the allegations and the charge in the indictment. You understand that?
Yes, sir.
Did you sign and swear to that stipulation of evidence states 2, freely, intelligently, knowingly, and voluntarily?
Yes, sir.
There's an agreement to stipulate testimony in the case. There's a form for a waiver of appeal. These are all signed by you and Mr. Robertson. There's a request for a waiver of the pre-sentence, which is approved by the court. Trial court certification of your rights to appeal, and then a certification from you back to the court, which contains your waiver of appeal. Now, all these plea documents signed and sworn to by you, I've identified for the record. Did you go over all these plea documents with Mr. Robertson? So you understood each plea document when you signed and swore to it.
Yes, sir.
Do you still wish to go forward on your plea of guilty to this state jail felony possession of a controlled substance without a jury?
Yes, sir.
Do you read, write, and understand English?
Yes, sir.
Have you consumed any in the last 24 hours?
Can you say that one more time?
Sure. Have you had any alcohol to drink in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, sir.
Do you understand everything you're doing in court today?
Yes, sir.
And you've been over everything about the facts of your case and everything you're doing in court today with Mr. Robeson, your attorney. Is that correct?
Yes, sir.
Is it competent, Mr. Robeson?
Yes, Your Honor.
Any of us have been confident, Mr. Chambliss?
No, Your Honor.
All right, court notes State's counsel signed his consent and approved the waiver of trial by jury. Court approves the waiver of trial by jury and all the other waivers in the case signed by the defendant, signed by his attorney. All right, now, Mr. Rollins, you understand all the allegations, the charge in the indictment, the full range of sentencing, your plea agreement for 5 deferred, and all your plea papers. Is that correct?
Yes, sir.
Do you have any questions for me about anything?
No, sir.
All right, in cause number 2410587-20, what is your plea today to the indictment charging you with the offense of possession of controlled substance, a state jail felony, as alleged in the indictment? Like, what is your plea? Is your plea guilty or not guilty?
Guilty.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, sir.
Okay, are you entering your plea of guilty to the indictment today because you are guilty?
Yes, sir.
And you are not entering your plea of guilty for any other reason other than the fact that you're guilty. Is that correct?
Yes, sir.
Anyone threaten you in any way or promise you anything or coerce you, make you plead guilty?
No, sir.
Are you entering your plea of guilty to the indictment freely, intelligently, knowingly, and voluntarily because you committed the offense charged in the indictment?
Yes, sir.
Are you entering your plea of guilty to the indictment today because you have any type of delusion in your mind or some type unrealistic hope of pardon, parole, or leniency?
No, sir.
Court does receive and accept your plea of guilty. What do you have, Mr. James?
Your Honor, at this time, we would offer states 1, the plea packet, states 2, the signed and sworn to stipulation of evidence, and states 3, the discovery compliance acknowledgement.
No objection, Your Honor.
With no objection, states 1, all the plea papers, states 2, signed, sworn to stipulation of evidence, states 3, discovery compliance, all approved by the court, admitted into evidence by the court with no objection. The court finding all these documents were done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find that the defendant's plea of guilty entered to the indictment was entered by the defendant to the indictment freely, intelligently, knowingly, and voluntarily. The court does receive and accept the defendant's plea of guilty. Will move to sentencing.
Your Honor, at this time, I would offer states 4, which is a digital copy of the state's written discovery.
No objection, Your Honor.
States 4, all non-offensive investigative reports, DPS lab report on the controlled substance, all admitted in with no objection. Court having admitted into evidence, state exhibits 1, 2, 3, having received and accepted the defendant's plea of guilty to the indictment, finding it was entered freely, intelligently, knowingly, and voluntarily. The court does follow the plea agreement, and the court does withhold a finding of guilt as to the defendant assesses the sentence at 5 years, deferred adjudicated probation, no fines assessed, court costs started, paid, restitution started, DPS in the amount of $180 for the lab fee analysis. Sentence is formally pronounced, the court finding the evidence in the record fully sufficient to support the defendant's plea of guilty. However, the court withholds the finding of guilt, follows the plea agreement, assesses sentence of 5 years, deferred adjudicated probation, withholding finding of guilt. Mr. Rollins, I have from you a waiver of appeal. It waives, gives up your right to appeal, waives and gives up your right to file a motion for new trial. Are you waiving your right to appeal?
Am I waiving my right to, what?
Are you like waiving your right to appeal today?
Can you explain it to me?
Sure. If you wish to appeal, number one, if you enter into a plea agreement, then you actually don't have a right to appeal if it's a plea bargain case. However, issues can come up that you may have a right to appeal that are not in front of the court at this time. What you are doing is by your waiver of appeal, waiver means giving up. So you've presented to the court, signed by you and Mr. Robeson, a waiver of your right to appeal, telling the court you do not want to appeal. Is that correct?
Yes, sir.
All right, court receives and accepts a waiver of appeal, orders to file in the papers of the cause. The court, now having followed the plea agreement, assess your sentence at 5 years, deferred adjudicated probation. Mr. Rollins, the court's probation officer, Mr. Shannon Coleman, is on Zoom also. We now have a different procedure, so I need to go through with you. Of course, you're obviously in jail. You'll be booking out at some point. When you do book out of jail, you'll be receiving a probation assignment form. I tried to hold this up the other day, but I didn't do a very good job on Zoom, so it didn't show up. But there's a probation assignment form, and you're going to get it when you book out.
Yes, sir.
Your probation assignment form is going to show you there's an X by the name Amber Meza, M-E-Z-A. She is your assigned probation officer.
Yes, sir.
Your appointment date to personally see her, for her to go over your 70 or so terms of your deferred adjudicated probation, is on Wednesday, August the 26th, 2020 at 1 o'clock. That date and time I just read is on the form. So you'll book on out at some point. You'll have this form.
Yes, sir.
As of right now, you're on all your terms and conditions of probation, like you cannot use, possess, or consume any controlled substance. But what you're going to be doing on Wednesday, August the 26th in 2020, on August the 26th at 1 o'clock, you have to be in the probation office, and then you will meet with Amber Meza, and she will go over all your 70 or so terms and conditions of your deferred adjudicated probation, and she'll be sure you understand all of them. Because if any time while you're on the 5 years deferred adjudicated probation, the state files a motion to proceed to final adjudication,
Yes, sir.
that's a motion alleging you have violated terms and conditions of your deferred adjudicated probation, like failing to report, failing to take a drug test, or taking a drug test and failing it.
Yes, sir.
And what that causes then on the motion to adjudicate, the judge orders and issues a no bond warrant for your arrest. And there's a hearing held in the court before the judge, not a jury. And if the state proves to the judge you have violated any term or condition of your probation, as I've said as an example, failing a drug test, then the judge can adjudicate your case, just a big legal word, meaning the judge would go back, find you guilty of this offense, and then the judge could assess your sentence up to the maximum 2 years in a state jail facility and a fine of up to $10,000 because you were on deferred adjudicated probation. Now, do you understand all this?
Yes, sir. But so August 26th, that's when I start the probation.
You're going to be on the probation when you step out of the jail. You're actually on the probation right now.
Okay.
It's unlikely you'll violate it in the jail, but it's possible. I've seen it before. But when you step out of the jail, to answer your question, yes, you'll be on all but 70 or so terms and conditions of your probation. You're actually on them right now, but the problem is you're not going to understand all of them. Obviously, you understand you can't possess, consume, or use any controlled substance. But the purpose of you reporting to Amber Mesa, as your form will show on Wednesday, August 26, 2020 at 1:30, is so she can go over with you each and every one of your 70 or so terms and conditions of probation. At that point, you should understand them.
Yes, sir. So like when I get out today, like I don't have to go see anybody or nothing.
When you get out today, you don't have to go see anybody,
Okay.
except you may want to go talk to Mr. Robertson to be sure you understand everything.
Yes, sir.
But that's why you get this form. It used to be when you booked out of jail, you went back straight to the probation department, so it was easy for me to determine whether or not individuals such as you in jail reported as ordered. Because when you booked out, you went to probation, but we can't do that now because of the coronavirus. So that's why you get this date in your slip that shows the date, and you've got it, Monday, August 26 at 1:30. But understand, you're on probation right now. You with me?
Yes, sir. I
The
understand.
reason you're on probation is because I'm gonna sign the judgment today.
Okay.
And so, in other words, like if you use or possess, consume any controlled substance, if somehow it shows up on the test, even though you hadn't reported in, it'll violate your probation, okay?
Okay.
You do live here in Tyler, Smith County, don't you?
Yes, sir.
All right. You have any other questions for me?
No, sir. That's all.
Okay, well, be sure to report as ordered. It'll cause a warrant for your arrest. If you have any questions you think of, go and see Mr. Roberson. He can answer all of them. And then your probation officer will go over all your terms and conditions on that date that's on your form. If there's nothing else, we'll be in recess. Defendant's continued in custody until he's booked out, and then he's ordered to report to the probation department on August the 26th at 1:30 to Amber Mesa. We're in recess.
Hey, Clifton,
Yes.
I never received any paperwork on Mosley.
He called yesterday and said he had submitted it to the front desk.
They didn't have it. So I guess we'll just need to reset it until we can find it.
Is Mosley in jail?
Yes, sir.
Yes, sir.
Is that Mosley?
No, he needs them.
Yeah, that's the fellow we just,
You're finished. If you can get Jabari Mosley.
we need, yeah, we need Mosley. All right, so the court is calling once Jabora Jabari Mosley, Mosley. He is now present before the court by Zoom with his attorney, Mr. Roberson, by Zoom. Court's probation officer, Mr. Coleman's present. State's counsel, Mr. Heath Chamness is present. I do have the file. Of course, the file shows, I believe it's already been indicated. The defendant was indicted for the offense possession of controlled substance, state jail felony as alleged in 241-1054-20, meth in amount of less than a gram, but I don't have any plea papers.
Yeah, Judge, I took the papers to the jail on Monday around noontime. Mr. Mosley called me yesterday. Per my instructions, he said he had filled out the paperwork, read over the paperwork, and returned it to the front desk. However, I guess they didn't send the paperwork over to the court, so we don't have that paperwork. You
Okay,
did fill out the paperwork, didn't you, Mosley?
Yes, sir.
Okay, well, if he's filled out the paperwork, I'll have Tabitha call over to the sheriff's department, have them locate the paperwork, and then we may be able to go ahead, since it's filled out, and get this done today, Mr. Robeson. I don't know. Let me look at the schedule here.
I'll see if I can find it, and if I can, we can get it done at 1:30.
Okay.
Okay, if they bring it on over, if they can find it, I'm sure they can, and bring it on over. We'll once we have it, I mean, it's reset to 1:30 today.
Yes, Your Honor.
Yes, sir.
All right, Mosley. Well,
Yes, sir.
We're going to locate that paperwork.
Yes, sir. God bless y'all.
All right, thank you.
You
Yes,
bet,
sir.
appreciate it. Let's see, who we going to next? Who was that? Was that Jordan? No,
Andre Whitwer.
that was Mosley. We got a Jonathan Lawrence, Morris with about 5 cases. That was Jabari Mosley. I'm sorry.
We're gonna do Wickware next, Judge.
We're gonna do him at 1:30.
May need to scoot off so maybe here.
What's,
Is this Wickware?
Yes, ma'am.
who's this?
Andre Wickware. We have 2 pleas for deferred. Do you need to go to North Shore?
All right, we are on the record in cause number 241-1057-20, State versus Andre Wickware by Zoom. He's present before the court with his attorney, Mr. Clifton Roberson. State's counsel, Mr. Chamness, is present. We're also on the record in cause number 241-1056-20, State versus Andre Wickware on an indictment charging burglary of a building. Mr. Roberson, you wish to waive the reading and formal presentation of the indictments in both cause numbers.
Judge, wait, the form reading of the indictment in both cause numbers, his name's correctly set forth in both cases. He knows the range of punishment, what he's charged with. He's gonna change his pleas from not guilty to guilty, Your Honor.
All right, Mr. Wickware, just raise your right hand. I'll get you sworn in. Do you solemnly swear the testimony you will give before the court in both these cause numbers today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, Mr. Wickware, first of all, I've already mentioned the first indictments we're going to take up is 241-1056-20. It's indictment charging burglary of a building, which is a state jail felony. Have you gone over the allegations in that indictment charging burglary of a building with Mr. Roberson, your attorney, so you understand all the allegations and the charge in the indictment?
Yes, sir.
You understand the full range of sentencing for the offense of burglary of a building is not less than 180 days to more than 2 years in a state jail facility, and the fine may be assessed of up to $10,000. You understand that?
Yes, sir.
Now, in cause number 241-1056-20, on the charge of burglary of a building, you have a plea agreement with the state, you and Mr. Roberson. It indicates to the court that if you do enter a plea of guilty to the offense of burglary of a building, state jail felony as alleged in the indictment, Mr. Chamness, who's also signed all the plea papers, is going to recommend 5 years deferred adjudicated probation. Is that your plea agreement in that case?
Yes, sir.
Is that it, Mr. Roberson?
That is correct, Your Honor. It's 5 years deferred on the burglary of a building and 10 years deferred on the burglary of a habitation.
Or is that the correct plea agreement on the burglary of a building, 5 deferred, Mr. Chamness?
It is, Your Honor.
All right, moving over to the other case now, cause number 241-1057-20, Mr. Wickware, State versus Andre Wickware, charges burglary of a habitation, a second-degree felony, as alleged in the indictment. The plea agreement in that case indicates if you do enter a plea of guilty to the offense of burglary of habitation, a second-degree felony, Mr. Chamness is recommending your sentence at 10 years deferred adjudicated probation. Is that your plea agreement in that case, Mr. Wickware?
Yes, sir.
Is that it, Mr. Roberson?
That's correct, Your Honor.
Is that your recommendation, Mr. Chamness?
It is, Your Honor.
All right, now, Mr. Wickware, have you gone over the indictment charging you with burglary of a habitation in 241-1056-20 with Mr. Robeson, so you do understand all the allegations, the charge, and the full range of sentencing on that indictment?
Yes, sir.
In cause number 241-1057-20, have you gone over the indictment in that cause number, so you do understand the allegations, the charge in the indictment for burglary of habitation, and the full range of sentencing for that offense charged in that indictment?
Yes, sir.
All right, now I have sets of plea documents up here that indicate they're signed and sworn to by you. I'm going to get one of the agreed punishment recommendations up on the screen, so that because I can actually easily read the signature, Andre Wickware. You'll see, like, when the agreed punishment recommendations go up, they're both signed by Andre Wickware. I just need to ask you if that's your signature. You see where they're right there, they're signed by Mr. Chamness, State's Attorney, by Mr. Robeson, Attorney for Defendant. On the line above, Defendant. On all these plea documents I've got in both cases, they're all signed by that signature, Andre Wickware. Is that
Yes, sir.
is that your signature?
Yes, sir.
When you signed or signed to the ones that are signed to in all these plea papers in both cases, did you go over all the plea documents in both cases with your attorney, Mr. Robeson, so you understand all these plea documents in both cases?
Yes, sir.
All right, now what I'm going to go through, I'm going to go through now and identify the plea documents. They're going to vary, and I'll tell you which ones in vary. Obviously, if you've got an agreed punishment recommendation, 5 deferred on burglary of a building, punishment recommendation 10 deferred on burglary of a habitation. Now, in both sets of plea papers, signed and sworn to by you, and I did get you sworn in before I got off into this, didn't I?
Yes, sir.
All right, we've talked about your plea agreements in each case. Now, each set of plea documents has the following plea documents: an acknowledgement of admonishments. All these are signed by you, signed by Mr. Roberson, signed and sworn to by you. There's an acknowledgement of admonishments in each set of plea papers. There is a waiver of trial by jury in each set of plea papers. Do you understand by this waiver of trial by jury, you're waiving and giving up your right to a trial by jury in both cases?
Yes, sir.
The next document I have is a waiver of confrontation and agreement to stipulate testimony in both cases. It's shown to be signed and now signed and sworn to by you. Each case, each cause number has a stipulation of evidence. The stipulations of evidence are signed and now sworn to by you. Also, these are all signed by Mr. Robeson. Do you understand the stipulations of evidence states 2 in each cause number are written judicial confessions or admissions by you under oath to all the allegations and the charge in each indictment in each cause number?
Yes, sir.
Did you sign and swear to each one of the stipulations of evidence states 2 in each cause number of your own free will, and sign and swear to each one voluntarily?
Yes, sir.
There are agreements to stipulate testimony in each cause number, and each cause number, Mr. Wickware, you and your attorney, Mr. Roberson, have signed waivers of appeal and waivers of motion for new trial. Waiver obviously meaning giving up. So in each set of plea papers and each cause number, you filed a document that waives and gives up your right to appeal and waives and gives up your right to file a motion for new trial. Do you understand that?
Yes, sir.
Then in each cause number, you've requested the court to waive the pre-sentence investigation and report, which the court has done. And then there's a certification in each set of plea papers for each cause number on advice you've received from Mr. Roberson on your rights to appeal in each cause number. Now, I've gone through and identified all the plea documents we have in each cause number. I'm going to go forward now and ask you a set of questions for the record. Be sure and understand that the questions I'm asking you now apply to your pleas in both cause numbers. Do you understand that?
Yes, sir.
All right, do you still wish to go forward on your plea of guilty to the indictment in each cause number? Understanding the plea of guilty will be done without a jury.
Yes, sir.
And you do understand all the plea documents, the charge in the indictment in each cause number, the full range of sentencing in each cause number, and your plea agreements in each cause number. Is that correct?
Yes, sir.
All right, all, as I've said, all these questions are asked to you for purposes of your plea in both cause numbers. Do you read, write, and understand English?
Yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined under psychiatric treatment or been in a mental institution?
No, sir.
Do you understand everything you're doing in court today?
Yes, sir.
Have you gone over everything about the facts of the case and the cases and
Yes,
all
sir.
all the plea documents with Mr. Roberson?
Yes, sir.
Is he competent, Mr. Roberson?
He is, Your Honor.
Any evidence of incompetence, Mr. Chambliss?
No, Your Honor.
All right, court notes State's counsel signed his consent approval of the waivers of trial by jury. The court approves the waivers of trial by jury and all the other waivers signed or signed and sworn to by the defendant, signed by his attorney. All right, now you do understand all the allegations, the charge in each indictment, all your plea papers, your full range of sentencing. Is that all correct?
Yes, sir.
Do you have any questions for me about anything in either case?
No, sir.
All right, in cause number 241-1056-20 to the indictment charging you with burglary of a building and state jail felony, what is your plea today to that indictment?
Guilty.
In cause number 241-1057-20, what is your plea to the indictment in that cause number charging you with burglary of a habitation, a second degree felony?
Guilty.
Are you entering your pleas of guilty today because you are guilty and for no other reason?
I am guilty. Yes, sir.
Anyone threaten you in any way or promise you anything to get you to plead guilty?
No, sir.
Are you entering your pleas of guilty today freely, intelligently, unknowingly, and voluntarily because you committed the offense charged against you in each indictment?
Yes, sir.
Are you entering your pleas of guilty to the indictments today as a result of any type of delusion you have in your mind or some type of unrealistic hope of pardon, parole, or leniency?
No, sir.
All right, the court does receive and accept your pleas of guilty to the indictment in each cause number, finding they were done and entered freely, intelligently, knowingly, and voluntarily. What do you have, Mr. Chairman?
Your Honor, at this time, we would offer states 1 in both cases. The plea packet states 2, the signed and sworn to stipulation of evidence, and states 3, the discovery compliance.
No objection, Your Honor.
No objection. In each cause number, states exhibits 1, 2, and 3 are all admitted into evidence without objection. The court finding all the plea documents in each cause number were done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment in each cause number was entered by the defendant to the indictment in each cause number freely, intelligently, knowingly, and voluntarily. We'll move to sentencing.
And Your Honor, in both cases, we would offer states 4, which is a digital copy of the state's written discovery.
No objection, Your Honor.
Case 4 is admitted into evidence. For purposes of sentencing in each cause number, the court does receive and accept the defendant's plea of guilty to the indictment in each cause number, finding the evidence in the record on the defendant's plea of guilty to the indictment in each cause number is fully sufficient to support the defendant's plea of guilty to the indictment in each cause number. However, the court does withhold a finding of guilt as to the defendant in each cause number, and the court does follow the plea agreements and the recommendations of the state and assesses the sentence at 5 years, deferred adjudicated probation for the offense of burglary of a building, and the court assesses the sentence at 10 years, deferred adjudicated probation for the offense of burglary of a habitation. The court finding that in each cause number, the evidence in the record on the defendant's plea of guilty in each cause number is fully sufficient to support the defendant's plea of guilty. Any legal reason for formal sentencing, Mr. Roberson?
No legal reason, Your Honor.
Finding none, the court does formally pronounce the sentence in each cause number. The court does found the evidence in the record fully sufficient to support the defendant's plea of guilty to the offense alleged in the indictment. The court does withhold a finding of guilt as to the defendant, each cause number, the court follows the plea agreement. The recommendation of the state assesses the sentence of 5 years deferred adjudicating probation for the offense of burglary of a building, and assesses the sentence at 10 years deferred adjudicating probation for the offense of burglary of a habitation, withholding a finding of guilt in each cause number as earlier indicated. Court has formally pronounced sentence in both cause numbers. Mr. Wickware, I have waivers of appeal from you, which give up your right to appeal in each cause number. Do you wish to present those waivers of appeal to the court now?
Yes, sir.
And also, do you wish to present your waivers of your right to file a motion for new trial in each case? Are you presenting those to the court now?
Yes, sir.
Court receives your waivers of appeal in each cause number. Court receives your waivers of your right to file a motion for new trial in each cause number. So as of right now, Mr. Wickware, in 1056-20, you're on the court's deferred adjudicated probation for the next 5 years. In 1057-20, that's the burglary of habitation, you're on the court's deferred adjudicated probation for the next 10 years. You've got 5 years deferred, 10 deferred. If you serve out the terms that you're on deferred adjudication for, it's just pronounced by the court, do not violate any of the terms and conditions of your deferred adjudicated probation, about 70 or so conditions on each one. If you successfully complete the deferred adjudicated probations, do not violate any of the terms and conditions, at the end of the terms, the state would dismiss the indictments against you, and you would not have a final conviction on your record for either one of these felony offenses if you successfully complete the deferred adjudicated probations. Do you understand that?
Yes, sir.
All right, and you'll have a set of about, as I've said, 70 or so terms and conditions of your deferred adjudicated probation. The number one term is when you book out of jail, listen closely. The number one term is when you book out of jail, you'll have in your possession a probation assignment form. It will have your name at the top. It will have an X by your supervising probation officer, Edwin Gonzalez. Counsel, was there any restitution on either one of these cases?
No, Your Honor.
All right, so you're assigned probation officer. If you look at your form, you'll see it when you get out, when you book out. Your assigned probation officer is Edwin Gonzalez. That's for both the cases. This form says you are scheduled, that's you are scheduled to meet with your probation officer on Wednesday, August the 26th, 2020 at 2:00 p.m. Do you understand that?
Yes, sir.
Also understand that's a term and condition of your deferred adjudicated probation in each cause number. So if you do not meet with your probation officer on Wednesday, August the 26th, 2020 at 2:00, I will get a violation report on you and sign no bond warrants for your arrest. Do you understand that?
Yes, sir.
You are meeting with your probation officer. You have the same probation officer in both cause numbers. You're meeting with your probation officer at that time because your probation officer goes over all the terms and conditions of your deferred adjudicated probation in each cause number. You got about 70 or so terms and conditions. Obviously, you cannot possess, use, or consume any controlled substance at any time because, and you do understand you're on the deferred right now. You with me on that?
Yes, sir.
You cannot use, possess, or consume any controlled substance. You have to complete any courses you're assigned by your deferred adjudicated probation officer. You have to report as ordered. If you fail to report as ordered, or you fail a drug test or violate any of the other terms and conditions of your deferred over the terms you're on for, the court will get a violation report and immediately sign a no bond warrant for your arrest. Then, once you're apprehended or voluntarily turn yourself in, the judge would conduct an adjudication hearing. You would be here, your attorney would be here, prosecutors would be here. If it's not a jury trial, if the evidence convinced the judge that you had in fact violated any term or condition of your deferred adjudicated probation, the court can grant the state's motion because the state's motions will allege violations. So after hearing evidence, if the court determines you have violated any term or condition of your deferred adjudicated probation, probably the ones most violated are failing to report as ordered, failing a drug test. But if you violate any term and condition, the judge can grant what we call a motion to adjudicate filed by the state. Well, if those violations alleged in the motion to adjudicate are proven to the court, not a jury, the court will grant the motions to adjudicate, which means the court will go back and find you guilty of the offense charged in each indictment, which means the judge can then assess your sentence at up to 2 years for the state jail felony burglary habitation. And the court can assess your the sentence at a maximum for the offense of burglary of a habitation, which would mean that the court in that case could assess your sentence up to 20 years in the Texas Department of Corrections Institutional Division and a fine of up to $10,000 because burglary of a habitation is a second-degree felony as set out in your admonishment. So do you understand if there's any violations, it's not a jury trial, proven to the judge, you can get up to 2 years in a state jail facility and you can get up to 20 years in the Texas Department of Corrections Institutional Division for the burglary of a habitation if you violate any of your terms and conditions. You with me on all that?
Yes, sir.
You have any questions for me about anything?
No, sir.
All right, now, when you book out, you be sure, you should have, and you be sure you've got your probation assignment form.
Yes, sir.
And Mr. Roberson will be sure you have it because the probation assignment form, as I've said once, maybe twice, but individuals for some unknown reason do not report when they're ordered by the court and no bond warrants would go out. So you're ordered to report on Wednesday, August the 26th, 2020, 2 o'clock. Mr. Roberson is going to have that time. You be sure and write it down and then report to your probation officers on that date in both cases. That's as clear as I can make it. Do you
Yes, sir.
understand all that?
Yes, sir.
Anything else, Mr. Coleman?
No, Your Honor.
Anything else, Mr. Roberson?
No, Your Honor.
Anything else, Mr. Chairman?
No, Your Honor.
We're in recess till the defendant's booked out of jail to report on the date stated by the court to his probation officer.
Yeah, same thing. Both of these. Both of them.
What do we have next, Tabitha?
Jonathan Morris.
Okay.
All right, you can go back to your seat.
Hey, Tabitha.
Mr. Roberson,
Yes, Clifton?
here's your defendant.
Okay, Jonathan is just gonna be a reset.
Okay. Incidentally, now these probation assignment forms, Mr. Coleman, actually there was one sitting to my left on the screen that the defendant would be able to see. But now that that's being done, I'll be referring to the screen so they can look at it.
Yes, Your Honor. Thank you.
All right, so I should have gotten that done earlier. So anyway, they'll be up there now. That one was actually up there. He should have been looking at it. All right, the next cases are cause number 241-1051, 20, 241-1052, 20, 241-1053, 20, Allstate versus Jonathan Morris, who's in jail on Zoom. All right, go. I'll say get your announcements, Mr. Chambliss.
Your Honor, he has a co-defendant whose cases were also set today, and those have been moved. And I don't remember what date Ms. Langston gave us yesterday, but they're in sometime in September.
I'm sorry, who's the co-defendant?
His name is Logan Carr.
I recognize that name, Logan Carr.
He's represented by Jason Parrish, but we had reset by agreement his cases until September. There's still some additional discovery and some additional work that needs to be done. And Mr. Roberson and I are still working on this case. So I don't have any objection to continuing his cases until the same date as Mr. Carr's. And we'll keep the plea deadline open on his as well.
They are continued to Thursday, September the 24th at 1:30.
They are continued to Thursday, September the 24th at 1:30. That's the same date, Thursday, September 24th at 1:30, that the co-defendant is already been rescheduled for, that Mr. Parrish represents. That's what Tabitha just told me. So is that, just for the record, it is agreeable, Mr. Robertson, and it's agreed between state and defense, Mr. Robertson, Mr. Chambliss, that these three calls numbers 1051, 20, 1052, 20, 1053, 20, all state versus Jonathan Morris, who's present by Zoom. These three calls numbers are continued over to that date I stated into the record, which I believe was September the 24th. September the 24th at 1:30. Defendants continued in custody will be back on Zoom at that date.
Thank you, Your Honor.
Whatever time they end up being set for, but it'll be on that day.
Yes, Your Honor. And Tabitha and Judge, on the Mosley, I did contact the low-risk facility. They're trying to track down that paperwork. I can inform the court it's a mandatory probation case, but he's waiving probation. And if we can set it for next week, that'll be fine. Hopefully they can locate that paperwork.
What's the defendant's name?
Jabari Mosley. Jabari Mosley.
Jabari Mosley.
Yes, Your Honor.
Okay, so you want to set that for next week, Mr. Robertson?
If we can, Your Honor, they're trying to locate the paperwork. I just got off the phone with low risk. They can't locate it. They're gonna try to track it down and see where that paperwork is.
Let's just see if we can go ahead and, well, we'll just reset it for next week.
They'll be fine, Your Honor, because
Let me see. I think I can just give you a date and time right now.
they'll be fine.
Go ahead, Tab.
We can do it Tuesday morning while you're here, Clifton. Tuesday, August the 18th.
Is that
They'll be fine. If you just give me a docket, I appreciate it.
Yes, sir.
Tuesday, August the 18th? I'm sorry, Tab. What time?
At 9 a.m.
Tuesday, August 18th at 9 o'clock. Mr. Chambliss, if you got that, it's on the, what was the Mosley case?
Yes.
You got that, Mr. Chambliss? I see Mr. Roberson writing it down.
I do. I'm actually writing on the phone right now, Judge.
Okay, that case is reset to that date. Court just stated into the record. Now, who's this we got right now?
Judge, I think we finished with low risk, and I think we got to, I guess, move downtown. I think we're finished with low risk.
Have you got anything else from low risk, Tabitha?
I did, but they closed off the screen.
Okay, hang on a minute. We're checking that out.
Yes, Your Honor.
Clifton, who is this in front of us now?
Who's
Oh, I
that?
can't see on my computer.
Sir,
Have a
can you,
seat.
can you, sir, can you state your name from jail?
Christopher Cooper.
Okay.
Oh,
Christopher Cooper.
They had it.
Judge, we can do him. You have plea papers on him. We can do Christopher Cooper.
All right.
He's getting 5 deferred.
All right, this is in cause number 24105, 70-20, State versus Christopher Cooper, who's before the court by Zoom from the jail. Mr. Roberson, his attorney, is present by computer, and Mr. Chambliss is present by computer, also known as Zoom. If you want to waive the reading and formal presentation of the indictment, all the other formalities, Mr. Roberson.
Judge Wade, the former reading of the indictment, his name is correctly says forth in the indictment, knows the range of punishment, what he charged with, gonna change his plea from not guilty to guilty, Your Honor.
Okay, Mr. Cooper, just raise your right hand. I have to swear you in. Do you solemnly swear the testimony you'll give will be the truth, the whole truth, and nothing but the truth, and that all these plea documents signed and sworn to by you were sworn to by you freely, knowingly, intelligently, and voluntarily?
Yes, sir.
All right, Mr. Cooper, I've got to go through these plea documents with you. They'll be going up on the screen. Of course, first one's your indictment, charging you with forgery of a financial instrument. As alleged in the indictment, that state jail felony offense carries a sentencing range of not less than 180 days to more than 2 years in a state jail facility. Fine may be assessed of up to $10,000. Do you understand that?
Yes, sir.
All right, now the other plea documents I've got, and that is your signature on the line above where it says defendant right there. Is that correct?
Yes, sir.
That signature, Christopher Cooper, is on all the plea documents. So your plea deal is plead guilty, 5 deferred. Court withholds the finding of guilt. Acknowledgement of admonishments, and you've signed all these and signed and swore to some of them now. 5 admonishments. You do understand you're waiving giving up your right to a trial by jury?
Yes, sir.
That waiver signed by you. You're waiving confrontation with witnesses, agreeing to stipulate testimony. You signed and sworn to, Mr. Cooper, a stipulation of evidence. It's marked as State's Exhibit number 2. It's up there on the screen. Do you understand that stipulation of evidence signed and sworn to by you and signed by Ms. Robeson? That's a written judicial confession under oath by you to all the allegations and the charge in the indictment. Do you understand that?
Yes, sir.
Did you sign and swear to that stipulation of evidence of your own free will and sign it voluntarily?
Yes, sir.
There's an agreement to stipulate testimony. There is a form for a waiver of appeal, request for waiver of the pre-sentence, which is approved. Trial court certification of your rights to appeal, and certification then from you back to the court on advice you've received from Mr. Roberson on your rights to appeal. Understanding all these plea documents, understanding your plea agreement, do you still wish to go forward on your plea of guilty to this indictment, charging you with forgery of financial instrument of state jail felony without a jury?
Yes, sir.
Do you read, write, and understand English?
Yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Do you understand? Have you ever been confined in a mental institution or under mental treatment?
No, sir.
Do you understand everything you're doing in court today?
Yes, sir.
Have you been over everything you're doing in court today with your attorney, Mr. Roberson, as well as everything about the facts of your case with Mr. Roberson?
Yes, sir.
Is he competent, Mr. Roberson?
He is, Your Honor.
Any evidence of incompetence, Mr. Chambliss?
No, Your Honor.
No State's counsel signed his consent approved of the waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers in the case signed by the defendant, signed by his attorney. All right, now, Mr. Cooper, you have gone over all the allegations, the charge in the indictment. You understand the full range of sentencing, your plea agreement, and all these plea papers you signed. Is that correct?
Yes, sir.
Do you have any questions for me about anything?
No, sir.
All right, in cause number 2410570-20, what is your plea today to the indictment charging you with forgery of financial instrument, a state jail felony?
Guilty.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, sir.
Anyone threaten you in any way, promise you anything, or coerce you, make you plead guilty?
No, sir.
Are you pleading guilty to the indictment freely, intelligently, knowingly, and voluntarily?
Yes, sir.
And are you pleading guilty freely, intelligently, knowingly, and voluntarily because you committed this offense charged against you in the indictment?
Yes, sir.
You are not pleading guilty because you have any type delusion in your mind or some type unrealistic hope of pardon or parole, are you?
No, sir.
Court does receive and accept your plea of guilty to the indictment. What do you have, Mr. Chambliss?
Your Honor, we would offer states 1, the plea packet, states 2, the sign and sworn to stipulation of evidence, and states 3, the discovery compliance acknowledgement form.
No objection, Your Honor.
No objection. States Exhibits 1, 2, and 3 are all admitted into evidence. Court having admitted into evidence, states 1, all the plea documents, states 2, the signed and sworn to stipulation of evidence, states 3, discovery compliance. The court does find all these documents under states 1, 2, and 3 were all done by the defendant freely, intelligently, knowingly, and voluntarily. The court receives the defendant's plea of guilty to the offense alleged in the indictment, finding it was entered freely, intelligently, knowingly, and voluntarily. However, the court at this time does withhold a finding of guilt as to the defendant. Will move to sentencing. Mr. Chairman.
Your Honor, at this time, we would offer States 4, which is a digital copy of the state's written discovery.
No objection, Your Honor.
States 4 is admitted into evidence with no objection. All the offense reports, investigative reports, other documents from the investigation, all admitted in as States 4. Anything else, Mr. Roberson?
No, Your Honor.
All right, the court in the case then, based upon the defendant's plea of guilty to the offense of forgery of financial instrument, state jail felony as alleged in the indictment, the evidence presented and admitted into the record by the court does find the evidence in the record fully sufficient to support the defendant's plea of guilty to the offense alleged in the indictment. However, the court does withhold a finding of guilt as to the defendant, follows the plea agreement and the recommendation of the state, session the sentence in the case at 5 years deferred adjudicated probation. No fines, assessed, court costs are ordered paid. Restitution orders as determined to be due, if any, by post-sentence investigation. Sentence is formally pronounced. Mr. Cooper, I have from you a waiver of appeal and a waiver of your right to file a motion for new trial. Are you presenting that document to me signed by you and your attorney today, understanding you're waiving your right to appeal?
Yes, sir.
All right, the waiver of appeal is accepted by the court, filed in the papers of the cause. Now, Mr. Cooper, I followed Mr. Chairman's recommendations as I normally do. Set your sentence at 5 years deferred adjudicated probation. You'll have about 70 or so terms and conditions of your deferred adjudicated probation. If you serve out the 5-year term or whatever term you're on for, which will not be less than 2.5 years, and you do not violate any of the terms and conditions of the deferred adjudicated probation, at the end of the term, the state will dismiss the indictment against you because you successfully completed deferred, and you will not have a final conviction on your record. Do you understand that?
Yes, sir.
The other side of the road, if any time while you're on this deferred, which could be up to 5 years, the state files what's called a motion to adjudicate with the court. The court with that motion to adjudicate, just a big legal word, meaning the state's filing a motion alleging you violated your deferred adjudicated probation in one or more ways. That would be stated in the motion. That would cause a no bond warrant to go out for your arrest. And then there will be a hearing held in this court before the judge, not a jury. If the judge determined from the evidence you had in fact violated any term or condition of your deferred adjudicated probation, the court would grant the state's motion to adjudicate, just a legal word, meaning the court would go back, find you guilty of the offense of forgery of financial instrument. Then because you were on deferred, the court could assess your sentence up to the maximum, 2 years in a state jail facility, fine of up to $10,000. You understand that?
Yes, sir.
So the way deferred is designed to work, if you successfully complete the deferred, pass all your drug tests, pay any restitution due, and don't violate any of the conditions of the deferred, at the end of the term, the state ends up dismissing the indictment against you and you don't have a final conviction. But if you violate any of your terms and conditions of your deferred, fail a drug test, fail a report, fail to pay restitution or whatever other conditions you've got, then when the state files a motion to adjudicate and the warrant goes out, when the hearing is held, if the judge determines you have violated any of your conditions of your deferred, conditions of probation, the judge can grant the state's motion to adjudicate, go back and find you guilty of this offense, forgery of financial instrument. And then because you violated, if you do terms and conditions, the judge can sentence you up to the maximum 2 years in a state jail facility, fine of up to $10,000. You understand all that?
Yes, sir.
All right, now we have another matter we have to go over, which ordinarily you'd be standing here in custody before the court, and I would just continue in the custody of the sheriff till you booked out, which would be later that day or the next morning. Then you'd be reporting directly to the probation office. However, now we have to do it different. Now you're going to get a piece of paper. It's up. It's actually, I've learned now, it's up on the screen. See where it says probation assignment form?
Yes, sir.
Has your name on it. If you come on down it, it has an X by Michelle Vasquez. Do you see that?
Yes, sir.
That is the probation officer who will be supervising you. You'll have her office email, her office phone number, and you'll have her cell number. So there's not much excuse for not being able to get in touch with her because you have to report in person to her on when, you see down at the bottom of the form, that appointment date, time, Wednesday, August the 26th, 2020 at 10:30 a.m.
Yes, sir.
You have to be in her office at that time unless she directs otherwise. You have to be in her office at that time to report to her in person because she's got to go over your 70 or so terms and conditions of your deferred adjudicated probation. That's a very important date because
Yes, sir.
if you don't report on August the 26th, that Wednesday at 2:20 at 10:30, unless she directs otherwise, there'll be a no bond warrant go out for your arrest. You with me on that?
Yes, sir. I'll be there.
You be there and you'll have the sheet. When you go out of the jail, you'll have this sheet that's on the screen right here. So
Yes,
you'll
sir.
have all your information you need to report on that date and time to Michelle Vasquez. Do you have any questions for me about anything?
No, sir.
All right, anything else, Mr. Roberson?
No, Your Honor.
Anything else, Mr. Chamness?
No, Your Honor.
My defendant's continued in custody until he is booked out with his probation assignment form with the date and time for him to report to his probation officer. We're in recess. You have someone else to.
Sir.
Do we have, no, it's okay. Do we have another one, Mr. Chamness or Mr. Roberson?
Judge, I think we have one that's downtown, and then I got 3 in my office that are out of jail.
Do y'all have Mario Lopez?
I think he's downtown.
That's where they are right now.
Okay, so we need Mario Lopez.
Thank you.
Thank you. I'm sorry. All right, we're on the record now in calls number 241-0580-20 State versus. I believe that's Mario, M-A-R-I-I-O, looks like Mario Lopez Jr., who's present before the court by Zoom. His attorney, Mr. Rose, is present before the court by Zoom. State's counsel, Mr. Heath Chamness, is present before the court by Zoom. Let me get into the file here, counsel, and get us up on where we are.
Yes, Your Honor.
It would appear to the court takes judicial notice of the file and all the prior proceedings. On August the 4th, 2020, the state filed a motion to adjudicate in this case, which obviously generated a no bond warrant for the defendant. He's obviously been taken into custody. Mario Lopez, and he's on Zoom from the jail in custody. I don't see any papers in here. What are the announcements?
Judge, it's my understanding, I've discussed this with Zach Gilmore, the assistant district attorney. We know that SafeP is not taking anyone into after the first of the year. I talked this over with my client and his mother. It's a situation, Judge, that they're going to be recommended that he go to SafeP. However, he's to remain in the Smith County Jail to after the first of the year until they can get him in SafeP.
All right, so I deduct from that and not seeing any plea papers in the file, then, Mr. Chamness, that all we're doing today is putting on the record what you just said, Mr. Roberson?
Yes, Judge, it's my understanding that they're going to dismiss the application, amend the term of conditional probation, that he go to SafeP, but he's to remain in the Smith County Jail until a bed space come available, and that could be January of 2021. He knows that.
That could be January of 2021.
Yes, Your Honor.
Mr. Chamness?
That's correct, Your Honor. Mr. Roberson was given basically an alternative offer on this. He was, I think Mr. Gilmore passed it on, but because the initial charge was a robbery, it came to me first. And I told him that based on the fact that the underlying offense itself, there was an indication that there was drug use involved, and then there's a positive UA here. I told Mr. Roberson he's got two choices. He can become a convicted felon right now and get a lower amount of time in TDC, or he can get off the dope and go to Safe P and get back on probation. And my understanding is that he wants to go to Safe P, and he knows that he may have to wait in jail, but that the agreement is he has to stay in the county jail until a bed becomes available.
That's our understanding, Your Honor. That's my client's understanding. And that's, I talked over with his family, his mom, his sister, and they understand the situation and think this is the best for him because of the drug addiction.
All right, the offense charged in the indictment, that's aggravated assault with a deadly weapon, second degree felony. I believe I've already mentioned it, but the state did file a state's motion to adjudicate guilt, which alleges violations by the defendant of his deferred adjudicated probation. There's four paragraphs in the state's motion to adjudicate guilt. I've already stated the date that was filed, which triggered the no bond warrant. Now, I understand what State and Defense Counsel, Mr. Chambliss and Mr. Roberson have said. I believe I understand it. I believe both State and Defense have agreed that Mr. Lopez, of course, this is a no bond motion to adjudicate, so he's not eligible for a bond. So he would be staying in the Smith County Jail until a bed in Safe P becomes available.
That is true, Judge. It's my understanding that bed space should come available sometime in January 2021.
So he would be looking at the earliest being in jail until January of next year, 2021.
Correct, Your Honor.
If there's a bed available in a lockdown Safe P facility,
Correct, Your Honor.
he would be going to a lockdown facility where you don't come and go. It's locked down, and if you don't successfully complete the Safe P program in the lockdown facility, then you end up coming back and facing a full adjudication hearing. So I just wanted to be sure I had that right, because it's going to be, from what y'all have said, it's, firm grasp for the obvious, 4 or 5 months at the best.
That's correct, Your Honor.
Okay, and the defendant is agreeable to this, Mr. Roberson?
Yes, Your Honor.
Well, I mean, obviously the option is the state going forward on its motion to adjudicate, and if the state prove the allegations to the judge, to the court would grant the state's motion to adjudicate, find the defendant guilty of the offense of aggravated assault with a deadly weapon, a second degree felony, which also alleges in the last paragraph, the second and then last paragraph, the use of a deadly weapon. I mean, that's the option. If the state goes forward on its motion to adjudicate, proves the allegations of the violations are true, the court would go back, find the defendant guilty of the offensive aggravated assault with a deadly weapon. The court could sentence him up to 20 years, and the court could make an affirmative finding that he used or exhibited a deadly weapon. Those are his options, which apparently Mr. Roberson, he has elected with you, or he is agreeable after this, I'm sure you explained it to him, of remaining in the Smith County Jail, and then when a Safe P bed becomes available, understanding that we're filling these Safe P units up as we're going along, but when a Safe P bed, but we don't make reservations, as I understand it. So when a Safe P bed becomes available, he's still in the Smith County Jail, and then at that time, there would be this motion to adjudicate hearing would take place, and the state would be agreeing with the defense to, let's see, he's on deferred adjudicated probation for how long right now?
I think a term of 6 years, Your Honor.
So at that time, when state defense are notified through our probation department, and for the record, Mr. Coleman is listening to all this. When a safe P bed becomes available, and state or defense are notified there's a safe P bed available for this defendant, we would conduct a hearing on the motion to adjudicate. And at that time, it sounds like the state would be agreeing with the defense to continue the defendant on deferred adjudicated probation on all his present terms and conditions with a new one, that he would be transferred from jail direct to a safe P lockdown facility and have to successfully complete that facility, drug abuse and other treatment in the safe P facility successfully as a term and condition of his deferred adjudicated probation. So if he waits in jail 4 or 5 months, goes to a state jail facility as a term and condition of being continued on deferred, and he violates any of the conditions in the safe P program and gets booted out, then the state at that time would be able to go forward on its motion to adjudicate, which would then include violations of the safe P program. And if the court found those allegations to be true, the court could adjudicate his case, find him guilty of aggravated assault with a deadly weapon, and assessing 20 years, up to 20 years in the Texas Department of Corrections Institutional Division. Mr. Lopez, do you understand all this?
Yes, sir.
Is that it, Mr. Robertson?
That's it, Your Honor.
Is that it, Mr. Chambliss?
Yes, Your Honor. And from a practical standpoint for the court, probably what the best thing that could happen would be for me to just get with Mr. Coleman and go ahead and do a motion to dismiss the application and amend the terms and conditions of his probation, putting in there that he has to go to Safe P, he has to remain in the Smith County Jail until a bed opens up, whenever that is. And then also included that he would be on ISP for 1 year after he gets out of Safe P. If I can get with Mr. Coleman, we can probably get that done, get it presented to the court so that the motion to adjudicate isn't before the court for another 2, 3, 4 months. He'll just know he's got to stay in jail until a bed opens up, and that'll be a term and condition of his probation.
I'd actually not gone on off into that, Mr. Chambliss, but I made the assumption that that is what you would be doing, so that we could have an order in place by the court setting out everything we just covered for the record, where there would be an order in place that he's to be continued at the Smith County Jail till the Safe P bed facility opens up, and then he would be transferred and have to successfully complete the Safe P facility as a term and condition of his probation. So if you get an order signed off on, obviously if you'll file the motion, get it signed off on by Mr. Robertson, he can have the defendant sign it if he needs to, then obviously I'll approve it. And then when that's what I would anticipate you would want to do. Then we'll have an order in place, setting all this out while he's sitting in jail, where it wouldn't appear that he's just sitting in jail. Be an order in the file which taking place. Is that it, Mr. Chambliss?
It is, Your Honor, and I'll get with Mr. Coleman and we'll get something put together.
Yeah, if you and Mr. Coleman just work that up, present it to Mr. Robertson. He can sign it, acceptable to him, and get the defendant to sign it. Anything else, Mr. Robertson?
No, Your Honor.
All right, defendants continued in custody under all these conditions in the agreement, and I'll sign the subsequent judgment when I get it, setting out all this. We're in recess. Defendants continued in custody.
Here you go, sir. Good. Yeah.
Here you go, Tabitha.
Clifton, we're now down to your office.
All right, which one you want to do first?
It does not matter to me. Hold on, let me see.
Okay, what about Braxton Jackson? I can get him here. He's from Louisiana.
Mr. Robertson, Mr. Robertson, the court's going to take about a 10-minute recess.
That'll be fine, Your Honor. We'll be ready when you're ready.
Have all your stuff ready, and we'll get those 3 done in your office.
Yes, Your Honor.
Just say court.
to the university in Shreveport, Louisiana. Yeah.
Hold on. Now you can.
You ready?
Now you can.
He's just bent over, maybe got sick. We're on the record in causing, I was just, I was thinking when I saw you bent over, I thought you might have gotten sick. That's all right. We'll go ahead. Cause number 2410577-20. State versus Braxton Jackson on indictment charging credit card or debit card abuse, state jail felony. He's present in Mr. Robeson's office with Mr. Robeson's attorney. You want to waive the reading presentation of the indictment, all the other formalities, Mr. Robeson?
Judge, waive the form reading of the indictment. His name is correctly set forth in the indictment. Those range of punishment, what he's charged with. Going to change his plea from not guilty to guilty, Your Honor.
Raise your right hand, Mr. Jackson, after swear you in. Do you solemnly swear the testimony you'll give before the court today will be the truth, the whole truth, and nothing but the truth, and all the documents which indicate you signed and swore to the document are being sworn to by you freely, intelligently, knowingly, and voluntarily?
Yes, sir. Yes, speak up.
Full trouble hearing you, Clifton. Clifton, I can't hear him.
Okay, speak up. Yes, sir.
All right, you can put your hand down. Got to go through and ask you some questions now. The indictment charges you with credit card or debit card abuse. Do you understand the allegations and the charge in the indictment?
Yes, sir.
Do you understand that carries a full sentencing range of not less than 180 days, nor more than 2 years in a state jail facility? Fine may be assessed of up to $10,000.
Yes, sir.
All right, I got to go through and identify these plea documents now. They're all signed by Braxton Jackson, or now signed and sworn to by Braxton Jackson. The first one's up there, the signature down the right side above the line where it says defendant. Is that your signature?
Yes, sir.
Did you go over each one of these plea documents with Mr. Roberson, your attorney, prior to the time you signed or swore to it, so you understood what you were signing?
Yes, sir.
All right, you've got a plea agreement in this case. If you plead guilty to this indictment charging credit card or debit card abuse, Mr. Chambers is going to recommend your sentence at 3 years deferred adjudicated probation. You'd be ordered to pay any restitution determined to be due by a post sentence. Is that it, Mr. Roberson?
That's correct, Your Honor.
Is that your recommendation, Mr. Chambers?
It is, Your Honor.
Also, all these documents, as I've already said, are signed by you. So, Mr. Jackson, you did go over all these documents with Mr. Roberson before you signed or swore to him. Is that correct?
Yes, sir.
There's an acknowledgement of admonishments that gives you a full range of sentencing, total of 5 admonishments. There's a waiver of trial by jury. You understand you're waiving giving up your right to a trial by jury?
Yes, sir.
You're waiving confrontation of witnesses. You've signed and now sworn to a stipulation of evidence, stage 2. Do you understand that stipulation of evidence is a written judicial confession by you to all the allegations and the charge in the indictment?
Yes, sir.
There's an agreement stipulation. Did you sign and swear to that stipulation of evidence, stage 2, of your own free will and sign it voluntarily?
Yes, sir.
There's a waiver of a motion for new trial and a waiver of appeal filed by you, an agreement to stipulate testimony. There is a request to waive the pre-sentence, which has already been approved by the court. We're proceeding without a pre-sentence. Your certification of the court on advice you've received on your rights to appeal. And all these plea documents signed and sworn to by you, Mr. Jackson. Do you understand all these plea documents?
Yes, sir.
Do you still wish to go forward on your plea of guilty to this indictment, charging you with credit or debit card abuse, a state jail felony without a jury?
Yes, sir.
Do you read, write, and understand English?
Yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, sir.
Do you understand everything you're doing in court today?
Yes, sir.
Have you been over everything you're doing in court today by Zoom and everything about the facts of your case with your attorney, Mr. Roberson?
Yes, sir.
Is he competent, Mr. Roberson?
Yes, Your Honor.
Any evidence of incompetence, Mr. Chambliss?
No, Your Honor.
Court notes states counsel signed his consent approved of the waiver of trial by jury. Court approves the waiver of trial by jury and all the other waivers in the cases signed by the defendant, signed by his attorney. All right, you understand all the allegations, the charge in the indictment, the full range of sentencing, and all these plea documents I've identified for the record. Is that correct?
Yes, sir.
Do you have any questions for me about anything?
No, sir.
All right, in cause number 2410577-20, what is your plea today to the indictment charging you with credit card or debit card abuse as alleged in the indictment, a state jail felony?
Guilty or not guilty? Guilty.
Can't hear you. I can't hear you, Mr. Jackson.
Oh, guilty?
All right, are you entering your plea of guilty to the indictment freely, intelligently, knowingly, and voluntarily?
Yes, sir.
Anyone threaten you anyway or promise you anything to get you to plead guilty?
No, sir.
Are you entering your plea of guilty to the indictment freely, intelligently, knowingly, and voluntarily because you committed the offense charged in the indictment?
Yes, sir.
Are you entering your plea of guilty to the indictment because you have any delusion in your mind or some type unrealistic hope of pardon, parole, or leniency?
No, sir.
The court does receive and accept your plea of guilty. What do you have, Mr. Chambers?
Your Honor, we would offer states 1, the written plea packet, states 2, the sign and sworn to stipulation of evidence, and states 3, the discovery compliance acknowledgement.
No objection, Your Honor.
With no objection, states 1, 2, and 3 are admitted into evidence. The court does find the defendant's waiver of his rights excused of all the plea documents were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment in this cause number was entered by the defendant to the indictment in this cause number freely, intelligently, knowingly, and voluntarily. Court finding the evidence in the record sufficient to support the defendant's plea of guilty. The court withholds the plea of guilty at this time and will proceed to sentencing.
Your Honor, we would offer states 4, which is a digital copy of the state's written discovery.
No objection, Your Honor.
States 4, all the offensive investigative reports are admitted into evidence. The court in this case then, based upon the defendant's plea of guilty to the offense of credit or debit card abuse, state jail felony as alleged in the indictment, the evidence presented and admitted into the record by the court. The court does find the evidence in the record on the defendant's plea of guilty is fully sufficient to support the defendant's plea of guilty to the offense alleged in the indictment. However, the court does withhold a finding of guilt and will move to sentencing.
And Your Honor, nothing other than states 4.
States 4 is admitted into evidence. The court of the case then, having received, accepted the defendant's plea of guilty to the offense alleged in the indictment, court having withheld a finding of guilt, the court does follow the state's recommendation to assess the sentence in the case at 3 years, deferred, adjudicated probation, no fines assessed, court costs are ordered paid, restitution is ordered as determined to be. Do we need a post sentence for restitution?
There's not any, Your Honor.
No restitutions indicated as due. Any legal reason for formal sentencing, Mr. Roberson?
No legal reason, Your Honor.
Finding none, the court formally pronounced the sentence. Court finds the evidence in the record on the defendant's plea of guilty to the indictment is fully sufficient to support the defendant's plea of guilty to the offense alleged in the indictment. However, the court does withhold a finding of guilt as to the defendant to the indictment charging credit card or debit card abuse. Follows the plea agreement with the recommendation of the state to assess the sentence in the case at 3 years, deferred, adjudicated probation, no fines assessed, court costs are ordered paid, no restitution indicated as due. Credit for time served granted, waiver of appeal, waiver of right to file a motion, new trials approved, received, and accepted by the court. Mr. Jackson, I have now placed you on 3 years deferred adjudicated probation. If you complete your 3 years deferred adjudicated probation, do not violate any of the terms and conditions of your deferred adjudicated probation. At the end of the term, Mr. Roberson can file a motion to dismiss the indictment, and if it's proven you have not violated any of your 70 or so terms and conditions, the indictment would be dismissed and you would not have a final conviction on your record. Do you understand that?
Yes, sir.
That's the way deferred can work for you. If any time during the next 3 years, up to the next 3 years, you're on the deferred adjudicated probation, if the state from its probation officer files a violation report with the court, saying to the court, you violated one or more terms and conditions and setting out the condition they say was violated, the court immediately issues a no bond warrant for your arrest. Then there's a hearing held in this court before the judge, not a jury. If the judge determines from the evidence you have violated any of the terms and conditions of your deferred adjudicated probation because you were on deferred, the court could then go back, find you guilty of credit card or debit card abuse, and with you having violated deferred, the court can sentence you to the maximum 2 years in a state jail facility, fine of up to $10,000. You understand all that?
Yes, sir.
All right, now with you sitting right there by Mr. Roberson in his office, he'll have for you a probation assignment form. This is extremely important. You'll be leaving Mr. Roberson's office with the probation assignment form. When you look down at it now, you'll see there's an X by the name Catherine Robertson, Robertson. She is assigned as your supervising probation officer. When you look over to the right, you've got her work email and her work phone number. Now, if you look on down towards the bottom, you can see in big print, you are scheduled to meet with your probation officer on Thursday, September the 17th, 2020 at 8 o'clock. Do you understand that?
Yes, sir.
If you're not in her office meeting with her on Thursday, September the 17th, 2020 at 8 o'clock, unless she has some reason why she resets your appointment time, if you're not there on Thursday, 17th of September at 2020 at 8 o'clock, she'll immediately send me a violation report and I'll issue a no bond warrant for your arrest. Do you understand that?
Yes, sir.
And then there would be a hearing held before the judge of this court. If the court determined you violated by not reporting as ordered, failing a drug test, or violating any of the other 70 or so terms and conditions of your probation, then the court can grant the state's motion to adjudicate. Legal word meaning the court would go back, find you guilty of the offense of credit card or debit card abuse as alleged in the indictment. And then because you were on deferred and violated it, the court could sentence you up to the maximum 2 years in a state jail facility, a fine of up to $10,000. Do you understand all that?
Yes, sir.
Be sure when you leave Mr. Roberson's office, take your probation assignment form. He'll be sure you do, because that's where that date is down there at the bottom in time when you have to meet with your probation officer, because she's got to go over your 70 or so terms and conditions so you know what they are, so you can follow all of them. Do you understand that?
Yes, sir.
Do you have any questions for me?
No, sir.
Hey, Judge, I can inform the court that he was over at the court this morning. He picked up all the paperwork from Tabitha. He has all the paperwork and is present. Also, Judge, he resides and lives in Bossier City, Louisiana. He's attending junior college there. Also, he has a prospect of going to the Division I school on a scholarship. And I told him if he has to go to any of those colleges, to visit colleges, to let his probation officer know. And he wants to get his probation transfer to Bossier City, Your Honor.
I will approve the transfer if it is approved by an order signed by his supervising probation officer. When does he want to have it transferred, Mr. Robeson?
Well, Judge, I informed them as soon as this, he would have to report it to Smith County to his transfer. He knows that he might have to make a couple of trips back here to Smith County, but as soon as they can get it transferred to Bossier City, he can appreciate it. Then his coach can have that information. So when he gets ready to have to go to other schools, they can let the probation officer know.
Okay, I'm following you now. He resides in Bossier City, Louisiana right now.
Yes, Your Honor.
Okay, so what school, what university or college is he in?
He's in a junior college in Bossier City.
Yeah, okay, that's fine, junior college. So what junior college is he in?
At first I was at Tyler Junior College. Now I transferred to Southern Shreveport University.
Okay, you were in Tyler Junior College. Have you transferred from Tyler Junior College to the university in Shreveport?
Right, Judge, he was playing football here at Tyler Junior College until this case, he picked up this case, and then he transferred where he lives in Bossier City to Southern University, which they have a junior college program, Your Honor.
Okay, I'm with you on all that now. So just be sure, as you've already clearly indicated, you understand. Mr. Jackson, just do report to your probation officer on that date and time on your sheet. And then the way we do that is if the transfer of your supervision over to Bossier City is approved by which I'm sure it will be approved by your probation officer, they'll send me the document and I'll approve it. Now, just so it's on the record that you understand it, all your terms and conditions, the 70 or so that you're on today, that your probation officer will go over with you, you'll still be on all those terms and conditions of probation when you transfer your supervision over to Bossier City. Do you understand that?
Yes, sir.
Sort of the bottom line on that is you'll be doing your reporting and your drug testing in Bossier City. You'll have a probation officer there. If you're a probation officer there, I hope this doesn't happen, but as an example, if you fail a drug test, your probation officer would send a violation report to your officer over here in Smith County in Tyler, and then the state would file its motion to adjudicate here that would cause a warrant to go out. Then they would bring you back here to Tyler, and the revocation hearing would be in this court. It's sort of a technical way of explaining that your case is not transferred to Bossier City, only your supervision. That's where you report and do your drug testing, meet all your other terms and conditions of your deferred in Bossier City. But if there is a violation with all you got going, it sure shouldn't be. But if there is a violation, they would send the case back over here for the court, for this judge, the court judge of this court, to conduct a hearing. You with me on all that?
Yes, sir.
All right, what position do you play?
I play defensive tackle.
All right. Probably if you stood up, you'd look pretty large. I figured that. Okay, well, you have any questions for me?
No, sir.
Okay, you got a lot going for you now. Don't run off in the ditch and violate some condition, because you just complete this deferred, follow all your terms and conditions, make your grades over there, stay in school, keep playing football, and everything will work out good for you, okay?
Yes, sir.
Anything else, Mr. Roberson?
No, Your Honor.
Anything else, Mr. Chambers?
No, Your Honor.
Anything else, Mr. Coleman?
Just briefly, Your Honor, I
Sure.
believe on the early paperwork that I've turned into the court, it has a 5-year term of deferred. I'll have to make the adjustment to reflect the accurate of 3 years deferred. He was placed on probation today.
Let me look real quick. I said 3. It's 3 is
It's
on
3.
Okay, it's 3.
It's 3.
Okay.
Oh, thank you.
Okay, thanks, Mr. Coleman. And anything else, Mr. Coleman?
Just briefly, Your Honor, we're going to meet with Mr. Braxton on August the 18th for orientation. I didn't realize he would be transferring out of state. We will meet with him after that orientation to go over the transfer paperwork, so we don't further delay that process.
Okay, I'm real glad you brought that up, because I'd given him that appointment date on the sheet of Thursday, September 17th, 2020, 8 o'clock. So now what you're going to need to do is be down at your probation. You're going to go down to probation. What's that date, Mr. Coleman? I'm sorry, I want to be sure Mr. Roberson has it to be sure he's got it.
Yes, Your Honor, August the 18th at 1:45 p.m. here at the probation department.
All right, so on that date that Mr. Roberson's writing down is going to give to you, and the record's going to reflect you've got it, on that date, you have to be here in Tyler at the probation department for them to go over all these regulations and requirements with you, because you have to have that before we can transfer the case to Bossier City. You with me?
Yes, sir.
Okay, so I'm glad Mr. Coleman brought that up. Mr. Roberson's writing the date down. You'll leave his office with it. you have to be back over here. Your next date is the date Mr. Coleman just got put in the record. Mr. Roach is going to give you. You have to be back over here at the probation department on that day in order to get everything arranged for us to transfer your supervision to Bossier City, okay?
Yes, sir.
All right, good luck. Thank you, Mr. Coleman.
Thank you, Honor.
All right, Clifton, who do you want next?
We can do Joshua. All right, that's it.
You gotta go to probation now?
No.
Oh, wait, till the end.
Till August 18th.
All right.
Appreciate it.
All right, thanks, man.
Appreciate it.
Tell Joshua to come in. Appreciate it.
Please put your mask on, Mr. Rose.
Okay, Your Honor. You want to see my SMU mask, right?
I want your mask with the pony on the front of it.
There it is, Judge.
Let me see, put it on.
Oh, I got my glasses on, Judge.
You got someone sitting within 6 feet of you you're talking to, and they got their mask pulled down.
Okay, Judge.
I know why they got their mask pulled down, so we can hear them.
Right.
I thought you would have a red pony on the front of that blue mask.
It is. See it?
I do now. Okay, that'll pass. Keep it on. All right, we're going to go on now to cause number 2410572-20 State versus Joshua Fouse, F-O-U-S-E. This is on an indictment charging the offense of theft of property, state jail felony, as alleged in the indictment. He is before the court there in Mr. Roberson's office, his court-appointed attorney. Mr. Chamness is present by Zoom, and the court's probation officer, Mr. Coleman, is present by Zoom. You want to waive the reading and presentation of the indictment and all the other formalities, Mr. Roberson?
Judge, waive the formal reading of indictment. His name correctly set forth in the indictment. Knows the range of punishment, what he's charged with. Going to change his plea from not guilty to guilty.
Okay, Mr. Faust, raise your right hand. I have to swear you in. Do you solemnly swear the testimony you will give before the court today will be the truth, the whole truth, and nothing but the truth, and all the documents which show you signed and then swore to the document are being sworn to by you freely, intelligently, knowingly, and voluntarily?
Yes, Your Honor.
Mr. Faust, do you understand all the allegations in the indictment charging you with theft of property, a state jail felony?
Yes, Your Honor.
Is this your signature? You're going to see the first plea paper going up. This plea agreement, it's signed right there. Looks to me like Joshua Faust, but is that your signature on the line above where it says defendant?
Yes, sir.
All right, now you signed and sworn to all these plea documents. I know you got a mask on, so can you speak up some?
I'm sorry. Yes, Your Honor.
There you go. Now we got you. My court reporter's actually taking all this down, so she has to be able to hear you. So you got a plea agreement. If you plead guilty to the indictment, Mr. Chairman, it's recommended 4 years deferred adjudicated probation. Is there any restitution, Mr. Chairman?
There is, Your Honor. The total amount of theft was a little over $3,000, but a good portion of it was returned. There's still $1,778 in restitution that's owed to Coles.
All right, then $1,700 and some odd cents. That is set by the court as a term of your deferred adjudicated probation, Mr. Rouse, meaning you have to repay that through the probation department as ordered by your supervising officer as one of your terms and conditions of your deferred. Have you gone over these plea documents now where you understand them all?
Yes, Your Honor.
All right, you've got a plea agreement. If you plead guilty to this theft of property, state jail felony indictment, Mr. Chairman, this is recommending your sentence at 4 years deferred adjudicated probation. One of your conditions of your deferred adjudicated probation will be payment of the full amount of restitution the court just dictated into the record, which Mr. Chairman has stated. There's an acknowledgement of admonishments. All these are signed and sworn to by you and signed by your attorney. Do you understand you're waiving, giving up your right to a trial by jury?
Yes, Your Honor. We went over that.
You're waiving confrontation with witnesses and stipulations of testimony. You're stipulating the testimony in the case. Do you understand that?
Yes, Your Honor.
Your stipulation of evidence is going up next. It states too. This is one of the documents you just swore to. Stipulation of evidence, I have to be sure you understand that's a written judicial confession under oath by you to all the allegations and the charge in the indictment. Do you understand that?
Yes, Your Honor.
Did you sign and swear to that stipulation of evidence freely, intelligently, knowingly, and voluntarily?
Yes, Your Honor.
The court approves states two, the signed and sworn to stipulation of evidence. There's agreement to stipulate testimony form for a waiver of appeal. Request for waiver of the pre-sentence, which is approved by the court. Trial court certification of the defendant's rights to appeal, signed by the defendant, signed by defense counsel. That'll be filled in if the court follows the plea agreement showing it's a plea bargain case. The defendant has no right of appeal, and then the court has from the defendant, Mr. Robertson, a waiver of his right to appeal in the plea papers. In addition, the court has the court certification on the defendant's advice. Actually, the signed and sworn to by the defendant now is a certification by the defendant of his rights to appeal. All these plea documents I've gone through and identified for the record, all signed or signed and sworn to by the defendant, signed by state's counsel. And I imagine Mr. Robeson has them there by you, Mr. Faust. Do you understand all the plea documents?
Yes, Your Honor, I do.
Do you still wish to go forward on your plea of guilty to this indictment that charges you with the offense of theft, a state jail felony as alleged in the indictment?
Yes, Your Honor, I do.
All right, do you read, write, and understand English?
Yes, Your Honor.
Have you consumed any alcoholic beverage in the last 24 hours?
No, Your Honor.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, Your Honor.
Have you ever been confined in a mental institution?
No, Your Honor.
Have you ever been under psychiatric treatment?
No, Your Honor.
Do you understand everything you're doing in court today?
Yes, Your Honor.
Have you gone over everything you're doing in court today with your attorney, Mr. Roberson, as well as everything about your case with Mr. Roberson?
Yes, Your Honor.
Is he competent, Mr. Roberson?
Yes, Your Honor.
Any evidence of incompetence, Mr. Chambliss?
No, Your Honor.
Court notes state's counsel signed his consent approval of the waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers in the case. Excuse me, signed by the defendant, signed by his attorney, or signed and sworn to by the defendant. All right, now in cause number 2410572-20, understanding all the allegations in the indictment, charging of theft of property, state jail felony, understanding the full range of sentencing, and all your plea documents, Mr. Faust. What is your plea today to the indictment charging you with theft of property as alleged in the indictment?
Guilty, Your Honor.
Are you entering your plea of guilty to the indictment freely, intelligently, knowingly, and voluntarily?
Yes, Your Honor.
Anyone threaten you in any way or promise you anything to plead guilty?
No, Your Honor.
Are you entering your plea of guilty to the indictment freely, intelligently, knowingly, and voluntarily because you committed the offense charged in the indictment?
Yes, Your Honor.
Are you entering your plea of guilty to the indictment because you have any type of delusion in your mind or some unrealistic hope of pardon, parole, or leniency?
No, Your Honor.
All right, the court does receive and accept your plea of guilty, finding it was entered freely, intelligently, knowingly, and voluntarily. What do you have, Mr. Chambliss?
Your Honor, we would offer states 1, the plea packet, states 2, the signed and sworn to stipulation of evidence, and states 3, the discovery compliance acknowledgement.
No objection, Your Honor.
With no objection, states 1, the plea document, states 2, the signed and sworn to stipulation of evidence, states 3, all admitted into evidence without objection. Court having admitted into evidence states 1, 2, and 3, the court does find the defendant's execution of all the plea documents were done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment in this cause and was entered by the defendant to the indictment freely, intelligently, knowingly, and voluntarily. Sentencing, Mr. Chambliss.
Your Honor, we would offer states 4, which is a digital copy of the state's written discovery.
No objection, Your Honor.
States 4, all the offense investigative reports submitted into evidence without objection. Court in the case then, having received and accepted the defendant's plea of guilty to the indictment, finding it was entered freely, intelligently, knowingly, and voluntarily. Court does withhold a finding of guilt to the defendant, finding the evidence in the record is fully sufficient to support the defendant's guilty plea. The court withholds the finding of guilt. The court follows the plea agreement, the recommendation of the state, and assesses the sentence in the case at 4 years, deferred, adjudicated probation, no fine assessed. Court costs are ordered as determined to be due. Any legal reason to bar formal sentencing?
No, Your Honor.
Finding none, the court formally pronounces the sentence. The court finds the evidence in the record fully sufficient to support the defendant's plea of guilty. to the offense alleged in the indictment, theft, state jail, felony. The court follows the plea agreement, says the sentence of 4 years, deferred adjudicated probation, no fines assessed, court costs are ordered paid. Restitution is ordered to be paid as a term and condition of the deferred if any is determined to be due by a post-sentence on restitution. Sentence is formally pronounced at 4 years for adjudicated probation. Mr. Faust, you filled out and filed with the court waivers, giving up your right to appeal, giving up your right to file a motion for due trial. Are you filing those waivers of appeal and waiver of filing a motion for due trial with the court today?
Yes, Your Honor.
Court receives a waiver of appeal, receives a waiver of motion to file a new trial. Mr. Faust, now, the court will be signing a judgment today, this afternoon. The court's judgment will make a finding that the court has received and accepted your plea of guilty. However, the court's withheld the plea of guilty and placed you on 4 years deferred adjudicated probation, which obviously means for up to the next 4 years, you're on the court's deferred adjudicated probation, which will have about 70 or so terms and conditions. Now, since you are there in Mr. Roberson's office, when we finish this proceeding by Zoom in Mr. Roberson's office, you're ordered to report on down to the probation department. However, now we have to assign you a report date. And you're going to be, Mr. Roberson has a probation assignment form. And you are ordered by the court to report to your probation officer. And the reason for that is your probation officer is going to go over your 70 or so terms and conditions of your deferred adjudicated probation. Your date to report is on your form, your probation assignment form, Thursday, September Mr. Coleman, is that the 13th or the 17th? How do you read that?
The appointment in September is on September the 17th.
Okay. Thursday, September the 17th, which is right there on your form, Mr. Faust, at 2020 at 9:30 in the morning. You're going to have this form with you. That's when you're ordered to report to your probation officer, Tara Simpson, because she's got to go over the 70 or so terms and conditions of your deferred adjudicated probation. So be sure you understand those terms and conditions of your deferred adjudicated probation. If you don't understand what she explains to you, and they do a good job of it, but you have any questions, be sure and ask her right then, because it's your responsibility to understand your terms and conditions and follow all of them. Do you understand that?
Yes, Your Honor. Thank you.
Anything else, Mr. Roberson? I've accepted his waiver of appeal, waiver of motion, new trial.
That's it, Your Honor.
All right, then you'll have the sheet. Mr. Roberson's probably already given it to you, showing your probation officer and your date and time to report Thursday, September 17th at 9:30 at the probation office. Do you have any questions for me, Mr. Faust?
No, Your Honor. Thank you very much.
All right, good luck.
Thank you.
Your Honor, if I may just briefly.
Go ahead.
Thank you, Your Honor. We also have Mr. Faust set to come in on August the 18th for orientation here at the probation department at 8:45 a.m.
August the 18th at 8:45 a.m. August the 18th, 8:45 a.m. That's your appointment when you have to be at the probation department. You'll be there with other probationers. Mr. Coleman has appropriately used the word orientation. That's when they go over a lot of information that you'll need. But it becomes a condition of your probation to be in the probation department at that date and time for your orientation session. Do you have that date and time?
Yes, Your Honor. We wrote it down.
All right. Anything else, Mr. Coleman?
No, Your Honor. Thank you very much.
All right. Thank you. All right. We're in recess.
Thank you, Your Honor.
Hey,
Good luck.
Clifton,
Clifton?
if you will send Joshua and William to me after we get finished, I'll give them their packets.
Okay, all right, I will.
Did you, Joshua,
This Joshua Faust.
you got him, Mr. Roberson?
Yes, Your Honor.
All right.
As soon as we finish with the next guy, I have him come over.
Thank
All
you.
right. Thanks. William Cox next.
Till Cox come in, and then when we finish with him, I have both of y'all go over there. Okay.
All right, we're now on the record in calls number 241-0169-20, State versus William Cox. William Cox is present in Mr. Roberson's office on Zoom with Mr. Roberson. State's counsel, Mr. Chambliss, is present. The court's probation officer, Mr. Coleman, is present by Zoom also. This is on indictment charging false statement for property or credit, alleging an amount that's a state jail felony alleged in the indictment. The court has a stack of plea documents here, of course, to go through and identify for the record. Mr. Cox, let me get you sworn in. Just raise your right hand. Do you solemnly swear the testimony you'll give at the cause now on trial today will be the truth, the whole truth, and nothing but the truth, and that all the documents which indicate they are sworn to by you are being sworn to by you freely, intelligently, knowingly, and voluntarily?
Yes, sir.
Can you speak up a little bit, Mr. Cox?
Yes, sir.
Okay, you can put your right hand down, but you got to be sure my court reporter, she's over to my right, and she's got to be able to hear you because she's taking down somehow everything we're doing.
Yes, sir.
All right, the indictment formal reading of the indictment having been read, we need to go through these. I'm going to identify all of these plea documents. Mr. Chambliss, this appears to be one of those sets that got down here, which isn't a problem. Got down here, well, hang on a minute. The first one, the agreed punishment recommendation, it's not a big deal. It's just not signed by you or any,
Okay.
or any of the assistants that work for you. I'm trying to see it. Well, heck of a note is though, looks like you signed the others.
I'll get a miss on that one when
We'll Tabitha will get you on that one. Somehow you just happened to miss the plea agreement, but it looks like the others that call for your signature that they're on all the others. Anyway, we'll go ahead with plea. All right, Mr. Cox, you understand the allegations, the charge in the indictment for false statement, property or credit. You understand that's a state jail felony. Is that correct?
Yes, Your Honor.
And you have been over all these plea documents with Mr. Clifton Roberson, your attorney, because you've either signed and sworn to the plea documents. Do you understand all of them?
Yes, sir.
You've got a plea agreement with Mr. Chambliss, you and Mr. Roberson. If you enter a plea of guilty to this indictment, Mr. Chambliss is recommending your sentence at 5 years deferred adjudicated probation. One of your 70 or so conditions will be payment of restitution. If restitution is due, it will be ordered by a post-sentence investigation. Is there some restitution?
Your Honor, the amount of restitution that was discussed with Mr. Roberson that he passed on to his client is it's $5,612.
$5,612 will be ordered to be repaid by you, Mr. Cox, as a term and condition of your probation, and you'll see it now written into your 70 or so terms and conditions of your probation. So your recommendation from Mr. Chambliss is 5 years deferred adjudicated probation. Now one of the conditions of your deferred adjudicated probation becomes payment of that amount of restitution within the time ordered by your probation officer. Do you understand that?
Yes, Your Honor.
Next document is an acknowledgement of admonishments. It just gives you the offense and the full range of sentencing for a state jail. Do you understand? Of course, you've signed and sworn to these documents. Do you understand all 5 admonishments?
Yes, Your Honor.
You understand you're waiving, giving up your right to a trial by jury?
Yes, Your Honor.
You've signed and sworn to a waiver of confrontation with witnesses. You have signed and sworn to now a stipulation of evidence. It's going to be going up on the screen. I need to be sure you understand that's a written judicial confession under oath by you to all the allegations and the charge in the indictment. Do you understand that?
Yes, Your Honor.
Did you sign and now having sworn to that document freely, intelligently, knowingly, and voluntarily, which was in your oath?
Yes, Your Honor.
There's an agreement to stipulate testimony form for a waiver of appeal, request for waiver of the pre-sentence, which is approved by the court, trial court certification of your rights to appeal and certification of you back to the court on advice you received on your rights to appeal. As I say, we have a waiver of your right to appeal in the file here in the set of plea papers. You do understand all the allegations in the indictment charging you with false statement to obtain property or credit, as well as all of your plea documents. Is that correct?
That is correct. Yes, sir.
Okay. Do you have any questions for me about anything?
No, sir, I do not.
All right. Do you read, write, and understand English?
Yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, or toxic, going to have any of those substances in your system?
No, Your Honor.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, Your Honor.
Do you understand everything you're doing in court today?
Yes, Your Honor.
Have you gone over everything about the facts of your case and what you're doing in court today with your court-appointed attorney, Mr. Roberson?
Yes, Your Honor.
Is he competent, Mr. Roberson?
Yes, Your Honor.
Any of us have been competent, Mr. Chambliss?
No, Your Honor.
Court notes State's counsel signed his consent to approve the waiver of trial by jury. The court approves the waiver of trial by jury. All the other waivers in the case signed by the defendant are signed and sworn to by the defendant, signed by his attorney. All right, now, Mr. Cox, you do understand all the allegations, the charge in the indictment, and the full range of sentencing, as well as all these plea documents you've signed or signed and sworn to that I identified for the record.
Yes, Your Honor.
Is that correct?
Yes.
Okay, do you have any questions for me?
No, Your Honor.
All right, in cause number 2410169-20, what is your plea today to the indictment charging you with a false statement to obtain property or credit? A state jail felony is alleged in the indictment.
Yes, Your Honor.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
I'm sorry, Your Honor.
I'm sorry. Let me make that sort of jumble that up. Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, Your Honor.
Anyone threaten you in any way or promise you anything to get you to plead guilty?
No, Your Honor.
Are you entering your plea of guilty to the indictment today freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you in the indictment?
Yes, Your Honor.
Are you entering your plea of guilty to the indictment today because you have any type delusion in your mind or some type unrealistic hope of pardon, parole, or leniency?
No, Your Honor.
All right, the court does receive and accept your plea of guilty. What do you have, Mr. Chambliss?
Your Honor, we would offer states 1, plea packet, states 2, the sign and sworn stipulation of evidence, and states 3, the discovery compliance acknowledgement.
No objection, Your Honor.
With no objection, states 1, 2, and 3 are all admitted into evidence. Court having admitted into evidence states exhibits 1, 2, and 3. Court having received and accepted the defendant's plea of guilty to the indictment, finding it was entered freely, intelligently, knowingly, and voluntarily. The court does find the evidence in the record on the defendant's plea of guilty to the indictment is fully sufficient to support the defendant's plea of guilty to the offense alleged in the indictment. However, the court does withhold the finding of guilt to the defendant. We'll move to sentencing. Mr. Chambliss.
We'd offer states 4, a digital copy of the state's written discovery.
No objection, Your Honor.
States 4 containing all the offense, investigative reports, all approved by the court, admitted into evidence of states 4. The court then does formally pronounce the sentence. The court does find the evidence in the record is fully sufficient to support the defendant's plea of guilty to the offense alleged in the indictment. However, the court does withhold the finding of guilt, follows the plea agreement, the recommendation of the state, sets the sentence in the case at 5 years deferred adjudicated probation, no fines, assessed, costs ordered paid. Restitution is ordered to be paid in full as determined, if any is due at this point, by a post-sentence investigation. Sentence is formally pronounced at 5 years deferred adjudicated probation with the court withholding a finding of guilt. Restitution is ordered to be made if not already paid as a term and condition of the deferred. Sentence is formally pronounced. Mr. Cox, I have a waiver signed by you and Mr. Roberson presented to the court. Waives gives up your right to appeal, and ways gives up your right to file a motion for new trial. Are you waiving your right to appeal, waiving your right to file a motion for new trial as shown in those documents?
Yes, Your Honor.
Are you waiving those rights, Mr. Cox, freely, intelligently, knowingly, and voluntarily?
Yes, Your Honor.
Court receives a waiver of appeal, a waiver of right to file a motion for new trial. Now, Mr. Cox, fortunately, you're sitting there in Mr. Roberson's office, which makes a lot of this a lot easier because Mr. Roberson has right there for you a probation assignment form The probation assignment form has an X right at the top because you're assigned supervising probation officers Tyler Westling. You can see that at the top of the form. When you go down to the bottom of the form, you see appointment date and time.
Yes, sir.
Thursday, September the 17th, 2020 at 10 o'clock. Be sure and keep this sheet. Put that date and time on your calendar because you have to be in Mr. Westling's office, your probation officer's office, on Thursday, September 17th at 10 o'clock. For the obvious reason, he has to go over with you one by one your 70 or so terms and conditions of your deferred adjudicated probation. He
Okay.
will ask you if you understand each one. Be sure you understand it. If you don't, tell him I've got a question about it or I'm not sure about it. He'll go back over it with you because he's going to check and indicate you said you do understand each term, because that's what you're going to indicate to him unless you tell him you don't understand. Because later, if he sends a violation report to Mr. Chamness will file a motion to adjudicate your case with the court. That'll cause a no bond warrant to go out for your arrest. And then you'll be brought into court under arrest at some point, of course, with a lawyer. Hearing will be held, and if the state proves you violated any terms or conditions of your deferred adjudicated probation, any of those 70 or so, the court would grant the state's motion to adjudicate. Just a legal word meaning the court would go back, finds you guilty of the offense charged in this indictment. Then because you were on deferred, court could sentence you up to the maximum 2 years in a state jail facility, fine of up to $10,000. You understand that?
Yes, sir.
Other side of the road, of course, is if you successfully complete your deferred adjudicated probation, all the terms and conditions of your deferred adjudicated probation, do not violate any, then on the filing of a proper motion, no sooner than half the time you're on deferred, the judge of the court can make a decision as to whether or not to discharge you from probation or to keep you on probation. That's solely up to the judge. Main thing is going into it, understanding if any conditions are violated. I mean, what happens is your probation officer sends a violation report to actually sends a violation report to the court. That doesn't even go through Mr. Chambliss. It comes straight to the court. I look at the violation report in it, and I sign a no bond warrant for your arrest. Then you're apprehended or come into court and the adjudication or revocation hearings held. So be sure that you closely follow all those terms and conditions. You shouldn't have any problem with it. Just be sure you listen to your probation officer when he goes over them all. There's a bunch of terms and conditions. You have to be sure you keep up with them and follow all of them. I have a waiver of appeal and a waiver of your right to file a motion of new trial. Are you waiving, giving up your right to appeal, waiving your right to file a motion for new trial? Those are also signed by Mr. Rosen. Are you waiving your right to appeal?
Yes, Your Honor.
Okay. Court receives and accepts the waiver of appeal and the waiver of right to file a motion for new trial, orders and file the papers of the cause. Mr. Coleman, he's a supervisor. He won't actually be your probation officer, but he's been here on Zoom for the record listening to all this. Do you have any questions you want to ask for the court to have Mr. Coleman answer about? Of course, he won't be going over the terms and conditions. The ones I see violated the most that I end up sending individuals to the penitentiary or a state jail for the most are failure to report as ordered for some unknown reason. They just fail to report as ordered. So then a warrant goes out and they go to the penitentiary or a state jail, or failing a drug test, or failing to carry out your community supervision orders. Yes, hours. Those are the ones violated the most. A lot of them, they just never get employed, never get a job. So just have to be conscious of all those conditions. Expect you to make the deferred. And Mr. Robertson, is there anything else Mr. Robertson will talk to you about it? But Mr. Coleman, is there anything else that you need to tell him?
Just Your Honor, just briefly, on August 18th, it's showing on my screen. The defendant's also scheduled to come and report to the probation department for orientation on August the 18th at 1:45 p.m.
That's actually, I believe, in all the probation cases we've been doing that. This morning now the report date is actually, and as usual, I'm glad Mr. Coleman brought it up, because you've got that actual before your supervision date, you have to report on August 18th to the probation department. That's an orientation session.
Yes,
Where
sir.
you and a lot of other individuals going on probation get a lot of information, directions from the probation office. It's actually a term and condition of your terms and conditions. One of them requires you to report on August the 18th at that date and time Mr. Coleman just said. Have you got that one?
Yes, sir. Yes, Your Honor.
Anything else, Mr. Coleman?
No, Your Honor, thank you.
All right, we'll be in a recess unless there's anything. You have anything else, Mr. Roberts?
No, Your Honor.
Anything else, Mr. Chamness?
No, but I'll come to the court and sign that front page.
That'd be a good idea. If you'll do that, that way we can wrap the paperwork up. We're in recess.
Yes, sir.
Is that our last one from Clifton's office?
Yes, we are done for the month.
Damn, it's a lot easier.